Any mention?
We're on 24, eh?
May I please, Your Lordship. Lordship, I beg to mention item 56.
21, huh? Yes.
Item 56, my lord.
Item
56.
56.
Yes.
Why?
Lordship, I have some personal difficulties.
No objection, Your Lordship.
Yes.
Obligation.
Please, Your Lordship, I beg to mention item number 47, Your Lordship. Chartered Council is out of session, so I am praying for 2 weeks.
No objection.
Mansuri?
Yes.
Yes, okay. 2 weeks.
Obliged.
Please, Lordship. Lordship, I beg to mention item 5 of the supplementary list. It's a hearing matter. For this Shillong Municipal Board, respondent 3 and 4, but
Why?
of some unavoidable circumstances, you cannot complete.
They won't allow.
We had informed them, my lord, also.
We were informed today morning only, Your Lordship.
We had informed them. I'm just praying for 1 week's time.
What's the difficulty?
Mr. Day is not available today, my lord, because of some personal
You're
emergency.
praying for?
Lordship, I'm for respondent 5. The promoter.
And you for government.
Praying for 1 week's time, my lord.
Your Lordship.
1 week's time, Your Lordship.
Obliged. Lords, I have a similar prayer for item 51, my lord.
What happened to Mr. J?
This is, my lord, for me to argue. I'm just praying for some 1 week to prepare it, my lord. There's some clarification. This was that dual post matter. Today I'm a little handicapped, my lord. I'm just praying for short.
Dual post matter or the two names?
The brother occupying the teacher post.
Mr.
And
Samay, you know
Mr. Kharwanlang was there, my lord. Lordship, I have
Other
after
side,
2
you
weeks.
inform them.
Mr. Kharwanlang is there, my lord. Stay.
You inform them.
Lordship, I'll inform them accordingly.
No, not you will inform. You have to inform them, otherwise we'll take it up, yes?
My lord, he's
For,
on next.
I'm for the
Yes,
petitioner.
He's on next, my lord.
Okay, yes.
After 2 weeks, Lordship, if I may. Obliged.
Obliged.
May please, Lordship. Lordship, I beg to mention item number 50, my lord. I've informed the other, at the site also I've informed actually.
Who's the other side?
Regarding the Nokma matter.
No objection, Your Lordship.
No objection.
Yes.
Must press, Lordship.
Please, Your Lordship, I beg to mention item number 54. Praying this matter comes out after 2 weeks, Your Lordship.
Why you keep on joining this matter?
Due to personal difficulty, Your Lordship.
Whose possibility?
The arguing counsel, Your Lordship.
There are 1, 2, 3, 4. Who's arguing counsel here?
Mr. Philemon.
Here.
Mr. Philemon Nombre, Your Lordship.
1 week. Yes.
Obliged.
Your Lordship. Item 60.
Item?
60. I had taken the consent of other side. Let it come after 1 week.
Yes, I am there, my lord.
Some urgency is there, correct? No.
No, my lord. But that interim order is there, my lord. That may continue.
Okay. 60. After when, Mr. General?
1 week, sir.
After 1 week. Yes,
Next
interim
week.
order will continue, if any.
Much.
If any. Yes.
May I please, Lordship, I beg to mention item number 57, Lordship. After 2 weeks, Lordship.
What's the matter about?
This is a termination from service, Your Lordship.
Okay, yes.
Apply, Your Lordship.
Much obliged, Lordship.
From supplementary list, item number 1.
Wait, please, Your Lordship. Lordship, I'm praying if this matter may be taken up at the end of the board, Lordship.
What is something?
Highly.
2.
I have similar prayer in this matter as well, Lordship.
Out of some time also.
3.
Three.
My lord, I'm praying.
Yes.
I'm praying if this matter can be taken up at the end of the board, my lord. Mr. Paul is on legs.
End of the board. Okay. Where's Mr. Pandey?
Yeah, he's online, I suppose.
You've got
online.
instructions.
Yes, my lord.
Are you agreeable to the offer?
And that's, I think he's on.
Are you agreeable to the offer?
Because the corporation has considered this because of the extent of the outstanding dues. The maximum, I have written instructions, the maximum that the the corporation can do is that an upfront payment of 1 crore be made. Yesterday, your lordship suggested 90 lakhs, 1 crore be made, and remaining can be adjusted in the other installments.
Right. Then we'll order accordingly.
My lord, let it come up at the, my lord, let it come up at the end of the board, my lord. Let it come up at the end.
This case is not fit to be entertained.
My lord, my
It's
lord.
just out of out of compassion.
My lord.
You know,
Yes.
like a mercy petition. Yes. You just they have one question. You pay upfront 1 crore. Then be reconnected by tomorrow. It's
Great.
4.
Forum. All Meghalaya. Say.
yes, Mr. General. What did you want to address the court on? Oh, Mr. Advocate AAG.
Lordship. Lordship, before I come to that, Your Lordship, if Lordship kindly have Lordship, yesterday, Lordship, my senior friend was arguing that regarding the the Indian Registration Act of 1960, Your Lordship. 1860, Your Lordship. If Lordship kindly have that act.
1860?
Yes.
Lordship is having that act. If Lordship kindly have Section 3, Your Lordship, registration and fee, subsection 5, Your Lordship. Subsection 5, Your Lordship.
Subsection 5 of?
3-5.
Lordship, yes.
Subsection 5 of?
The Indian Registration Act or Indian Societies Act 1860.
Section 5 or subsection 5?
Subsection 5.
Of?
5.
Lordship, if I may read, Your Lordship.
What page is it?
Lordship, I am having the Act, Your Lordship, that is at page 11, Your Lordship.
They shall be paid.
Lordship, if Lordship kindly come to the main section, registration and fees.
Yes. Yes. There's so many state amendments.
Yes, that is a state amendment, Your Lordship.
Where's 3?
Maybe from time until page shall be
They
paid
shall be paid to registrar.
for the state government, Your Lordship. Yes.
Then there's still it is a mega state
Lordship
amendment.
kindly see, Your Lordship, and then Lordship kindly come to the writ petition.
No. Okay. You said 3, section 3 what? Subsection?
This is a registration and fees, Your Lordship. That is a state amendment, Your Lordship. That is a state amendment from Uttar Pradesh, Your Lordship. What I mean to contend here, Your Lordship, because they admittedly, Your Lordship, the organization here, Your Lordship, the registration had already expired in the 2016, Your Lordship. 2016, Your Lordship.
Yes.
So, for this period, Your Lordship, no fees has been paid, Your Lordship.
No, don't go there. The thing is that when they filed it on that
Lordship, I'm coming
day,
to that.
just
Lordship,
listen to
yes.
the report. Now, Mr. Jindal's client, after pointed out that the registration expired, then applied the next day.
Lordship.
And it was renewed.
Lordship.
On payment of fees.
Lordship.
Correct.
Lordship.
So
yes.
that as it stands, the renewal is there till 2027. or 29, whatever.
Lordship, yes.
No, but Mr. Jindal has severely stated that there's no power of registrar to renew.
Lordship, that is not
incidental question.
That is not the pleading, Your Lordship, in the writ petition.
No, the previous that the rose. He said that
Lordship,
there's no power to
Lordship,
renew.
to that effect, if Lordship, if I may please the rule.
That means he's arguing against his own case that the renewal also is without any lawful authority.
Lordship, we have the rules. That is the, if Lordship, Lordship, registration act. Yeah, he was there. If Lordship kindly have section 36 of the Meghalaya Registration Act.
What is this?
Lordship, that is the rule, Your Lordship. Lordship, first, Lordship kindly have section 36 of the main act. That is the Meghalaya Societies Registration Act.
Have we given all the
Lordship, in fact, given.
Section
36, Your Lordship. The rule making power of the state, Your Lordship.
Yes.
Then Lordship kindly see the state government may make rule for carrying out the purposes of this act, Lordship, to then up to 2E, Your Lordship.
Yes.
Then Lordship kindly have the amendment rule, Your Lordship, of September 2012.
Yes.
Lordship kindly have rule 2. Rule 1, Your Lordship.
There's renewal powers there.
Lordship, yes. This rule may be called the Meghalaya Societies Registration Act, Registration Amendment Rule 2012. Then Lordship kindly see 2. After sub rule E of rule 3 of the Meghalaya Societies Registration Rule 1985, herein after referred to as the principal rules, the following new sub rule F shall be inserted, namely renewal for registration societies. The certificate of registration issued under the Act shall be renewed for every period of 3 years. Application for renewal shall be made to the Registrar of Societies in Form 1A appended to this rule and shall be accompanied by fee prescribed by the schedule.
So your contention is that since there's the gap from 16
Lordship,
to
yes.
26,
My contention, Your Lordship, my contention, when on the date when the writ petition was filed and on the date when the order passed by this honorable court, Your Lordship, the association, Your Lordship, is an unregistered society, Your Lordship, and for that, Your Lordship, it cannot maintain a writ petition, Your Lordship. If
so now whether the court in this discretion, since they have come up with a renewal certificate,
Lordship, that is subsequently, that is subsequently, Your Lordship. That is subsequently, Your Lordship. What I mean to contend is, Your Lordship, on the day,
we understand.
on the day, Your Lordship. So, as on the day when the writ petition was filed, as well as when the order was passed by the
society did not exist.
it is not. It ceased to exist, Your Lordship, by operation of the amendment rule of 2012, Your Lordship.
Yes, Mr. Vijay.
If Lordship permits me, may I please some case law on that, Your Lordship.
Yes, what case law?
If Lordship, if I may please, I can talk you. Sorry. If Lordship, this is the Meghalaya Wine Dealers Association and another business state of Meghalaya. Lordship kindly have paragraph 9. 9, Your Lordship. The meaning of locus standi.
Yes.
The meaning of locus standi in New Lexicon Webster Dictionary is given as the right to appear in court or to be heard on any question in the case of so-and-so when the issue of locus standi came to be to the forefront before the Supreme Court of India, then in order that the court may investigate the validity of a particular ordinance or act, the person moving the court should have a locus standi. If he has no locus standi to move the court will refuse to entertain his petition, question the bias of the particular legislation in view of the precedent order passed so-and-so. The petitioner has lost this locus standi to move the court during the period of emergency. Then, Lordship kindly have then legal personality mean person who are regarded under the law as person having capable of exercising right or having duty to have locus standi to move writ application. Individual person aggrieved by any action or inaction of the power of the state or the authority under Article 12 or Article 226 of the Constitution of India, which infringe his or its right or have been prejudicially affected by any order, can move the writ application. Similarly, partnership, firm, company, body, corporate, authority created by and under
this case only for one registration, there's no locus.
No locus, Your Lordship. Then another aspect, Your Lordship, will kindly consider one aspect of the matter, Your Lordship.
What happened here is that Okay, on the day when they moved petition, no locus, but they've corrected the.
Then Lordship will kindly consider another aspect of the matter, Your Lordship. Here, Your Lordship, admittedly, Your Lordship, they are the contractor. They come under one organization, Your Lordship. Then Lordship will kindly consider whether they are not capable, Your Lordship, of approaching this on court individually, Your Lordship.
No, what have an association? What prevents them? That will not be a.
Then another judgment, Your Lordship, if I may, Your Lordship.
The ground direction that's sustainable. Regarding that unregistered society, that's settled law.
Lordship, kindly see, this is a PIL number 2, 2013, and Lordship happened to be the counsel at that time.
Yes.
Lordship, kindly have para 9 of that judgment.
Yeah.
The first issue for consideration is as to whether the petitioner is a registered society. Respondent number 7 and 8 have contended that there is no record or any social activities carried out by the petitioner in the area of operation, that is Sheila and Nontrai village. Under the Right to Information Act, they have obtained the information that there is no non-governmental organization under name and style Sheila Action Committee Rally of the Sheila Native, registered under the Meghalaya Registration Act 1983. However, an organization under the name and style the Rally of Sheila Village Native was registered under the Societies Registration Act, which is non-functional as the organization has not been renewed. So this PL also has been dismissed, Your Lordship.
Yes, I remember.
So my humble and respectful submission, Your Lordship, on the question of locus, Your Lordship, the association being an unregistered organization, as on the date when the writ petition was filed, as well as on the date when the order was passed, because of the preliminary objection raised by the state, Your Lordship, this writ petition, Your Lordship, cannot be entertained, Your Lordship.
Yes.
Lordship, yes, sir.
Your Lordship, first with regard to the notification dated 17th September 2012,
yes,
which my learned friend has pointed out, subsection 2 of section 1, it says that it shall come into force from the date of issue of notification in the official gazette.
yes.
No notification, Your Lordship. No notification.
There's no notification till date.
Lordship, this is the instruction we have from the DC office. This is the rule given from the DC office, Your Lordship. It was registered before the DC office.
Well, should have been notified since. Anyway, you're positive about that.
No, Your Lordship, I have checked up through all the websites and internet, Google, and my client have inquired from the registrar office. I am told that there is no notification issue.
Additional evidence.
And that is one submission with regard to this notification. Second submission is this, that Meghalaya Society original principal rules, Meghalaya Society Registration Rules 1985, to which clause 3F is added, are not before my Lordship. We cannot read clause 3F in isolation of the entire clause. And I'm also informed that Meghalaya Society Registration Rule 1985 are also not notified, and it is nowhere found in the...
So what are we to do then?
Then I'm coming to that.
Then your site not
no, Your Lordship. I'm just please have patience.
Yes.
I'm just pointing out, Your Lordship. Pointing out, and coming to Your Lordship, that two judgment which my learned friend has cited. In both the cases, the society was unregistered society, and here we are not dealing with a case where the society was unregistered. It was a registered society, and the only submission of my learned friend is this, that on the date when I filed a writ petition, I filed a writ petition on 2nd. And on 2nd it was not renewed.
Yes.
2nd it was not renewed. No order is rendered on 2nd. I mean, no effective order is not rendered. Question of maintainability was raised by my learned friend. So unless the question of maintainability is decided, we cannot say the writ petition comes into existence at all, Your Lordship. And another thing, my learned friend has also raised a point that what prevented the individual member.
No, we're not going to go there.
Just, Your Lordship, for the information of this honorable court, that petitioner number 2 has come in the personal capacity. There are 2 petitioners. One is association, other one the person.
Yes.
In personal capacity, he has approached this honorable court. Now, Your Lordship, I cite one very important judgment of the Honorable Allahabad High Court Division Bench judgment, where the issue was similar. 2022 SCC online Allahabad 1083. Your Lordship, this is a little unfortunate because in this judgment the pagination is not given and the paragraph is also not given. And I'll just take to Your Lordship, it starts from page 1083, then 1084, then 1085. I have written with the with my pen. 1085, 1086.
See, just from the page on the, is it printed out from the website? Just from the
yes,
page
it
one on top. See, the pages are given here, on top here, right?
Oh, sorry, sir. I missed, Your Lordship.
Yes.
I missed.
Yes.
I come to Your Lordship, page 6.
Okay.
Page 6.
Yes.
Down second para.
Yes. Having noted
the background facts of the case as narrated above, the question which primarily fall for our consideration are as to whether, as contended by the learned counsel for the appellant, the writ petition filed by the petitioner number 1 and 2 was maintainable, and that is the question which we are concerned here. Second question I am not taking to bothering Your Lordship. That is the first question, as to whether, as contended by the learned counsel for the appellant, the writ petition filed by the petitioner number 1 and 2 was maintainable. Then second para, it has been argued on behalf of the appellant that the registration of the society having not been renewed after 26/9/2003, whereby renewal was valid for 5 years with effect from 10/10/2000, the writ petition filed by the petitioner number 1 society was not maintainable. When we consider this submission, we find that the contention is based solely on the ground of non-renewal of the registration of the society. Section 3 of the Act provides for registration of a society upon presentation of memorandum of association before the registrar on payment of certain fees. Section 3A of the Act provides for renewal of certificate of the registration of a society. Scheme of Section 3A of the Act as applicable in the state of Uttar Pradesh permits renewal of certificate of registration even after expiry of the period of registration on payment of late fees. Thus, a society once registered will not get extinct. That is to say, it will not become non-existent in absence of renewal of the certificate of registration after expiry of the term of registration. The society shall still exist, though with a non-renewal certificate. It will still be an entity for the reason that Section 3A permits renewal of the certificate of registration even after expiry of the term of registration on payment of late fees. Existence of society will not get extinguished only because of non-renewal of registration
Okay, yes, no,
certificate.
we get your point. The thing is that that's earlier judgment also, 1860 and the Act. What other?
Yes, last time I cited.
Anyway,
I think on yesterday.
The only thing we have to examine now, fine. The fact that it was registered, that is a legal entity as an association society registered, that is not in dispute, correct?
Yes, Lordship.
But whether you can maintain writ petition.
That's what your Lordship.
Unregistered society.
That's what your Lordship.
What are the consequences?
Lordship,
what are the consequences?
that is what I was reading, your Lordship.
You being registered, that is fine.
Yes.
Then see.
Your Lordship, it's not that I am not registered today.
As soon as you are registered, you acquire legal personality, correct?
Yes, Lordship.
Yes.
That
but
remains.
What happens when the legal personality does not renew registration? It can be a legal entity.
Yes,
but
Lordship.
It can maintain writ petition.
Yes, Lordship. Then it has to be dissolved. And that
dissolution is dissolution of the entire legal entity.
Lordship, just allow me
whether
to.
you can maintain legal entity, fine. Whether you can maintain writ petition.
Yes, Lordship. That is what I am trying to point out, your Lordship. Just give me. It will still be an entity for the reason that Section 3A permits the renewal of certificate of registration even after expiry of the term of registration on payment of late. Existence of society will not get extinguished only because of non-renewal of its registration certificate. Section 13 of the Act provides for dissolution of a society and therefore adjustment of its affair. Accordingly, we have no hesitation to hold that a society once duly registered does not lose its entity as a society on account of non-renewal of the certificate of registration. The society will get extinct only when it is dissolved as per the provisions contained in Section 13 or 13A of the Act. So far as the judgment cited by the learned counsel for the appellant in this regard, as mentioned above, are concerned, all the cases related to non-registered society and unincorporated club, and it is in this context that it has been observed that such a society will have the character of an association which cannot sue or be sued except in the name of all members of the association. In the case of Arya Samaj, it has been held by a division bench of this court that as soon as a society is registered, it acquires a legal entity. We are thus of the opinion that non-renewal of certificate of registration may have certain consequences, however, that in itself cannot be a cause of extinction of existence of the society as an entity. The existence entity of a society comes to an end only on its dissolution as envisaged under Section 13 and 13A of the Act. Then your Lordship come to the next page.
Still does not answer the question.
No, your Lordship will get the answer, your Lordship. And then fourth line. Thus, your Lordship got, thus in our opinion, the submission of the learned counsel for the appellant that the writ petition was not maintainable at the behest of the petition number 1 is not tenable.
Yes.
Similarly, the submission raised by the learned counsel for the appellant that the writ petition was not maintainable at the behest of the petitioner number 2 is also not tenable for the simple reason that he is one of the person included in the list of 16 members of the general body of the society. So, your Lordship, the contention raised by the appellant that the writ petition is not maintainable because the certificate of registration was not renewed has been squarely answered, your Lordship, and it says that writ petition is maintainable, and it is as contention was found to be not tenable, your Lordship. Similarly,
Go to Supreme Court.
No, this Supreme Court judgment, your Lordship, yesterday I have pointed out.
I know against this order.
No, there is no.
Well, what will be the consequences of non-registration or non-renewal?
Non-renewable, just give me the
Right,
Meghalaya.
it'll not
No, in relation to your lordship,
please listen, it'll not cease to exist as an entity.
yes,
But what are the consequences of
non-registration. Yes, that's what your lordship.
It's not non-registration or non-renewal.
Non-renewal.
on that day it can be
Non-renewal in the sense that it becomes defunct.
Defunct.
Becomes defunct.
Once becomes defunct,
And defunct. And non-renewal is provided in the, like in other act, which I was just reading, that section 13 speaks about the dissolution. They say there is a provision under section 13 and 13A.
Yes, that's also
and
the society will cease to exist as an entity once it's dissolved.
Dissolved by whom?
Made observation.
Dissolved by the
society
in accordance with the law.
Yes, and access apportioned to any other society. That is a part of it's another part of it. The only question we have is that what are the consequences of a society whose registration expired?
No, that power, your lordship, is vested with the registrar and the court and the society itself to dissolve.
No, dissolve, forget dissolve. We're not even on that page of dissolve.
Yes.
I'm saying, what are the consequences of not having a valid, it's like a car
yes.
with a expired
yes.
permit.
Yes.
So, the car is there, you can't deny it.
Yes.
The car permits exist, but the permits expired.
It has to be, consequences is only
What
this.
are the consequences?
Consequences is only this, that the registrar has to take a action. And
will they be entitled to any reliefs in a petition then?
Registrar has to take a action. So far
See, please listen, try to understand what I'm trying to say. Now we're saying entity, yes, will exist. But now the registration expired. Now what reliefs will be entitled to? You suppose if I file a petition, fine. What reliefs will he be entitled to? Will he be entitled to reliefs as a society?
Yes.
Yes.
Yes, lordship. Because
renew the registration.
No, writ petition, your lordship. That's what your lordship. I'm trying to impress upon.
I'm trying to understand, Mr. Chandra.
I'm trying my level best, your lordship. Maybe I lack in.
No, it's from you. Because
I'm so far, your lordship. I have known the things. I'm trying my level best to place before your lordship, and I may fail in my.
No. Don't need to get personal. What are the consequences? This court.
No consequences, your lordship. Consequences is not provided either under Incorporated Rule 3F. It is not provided. It is provided in the Act that dissolution is he can call for the report. He can call, the remedy lies with the registrar. And it is the registrar who has to take the action. And even if the court finds that yesterday, I will again take to your lordship to same Supreme Court case where the single bench of where the High Court has held that registration is invalid. Supreme Court stepped in and said that no, it is for the registrar to take a call and decide it. And so far the consequences are concerned. And consequences are concerned. And here we are concerned only with one point, that whether writ is maintainable or not. I have tried my level best to show your lordship that writ is maintainable.
What is maintainable? What are the consequences of not having a valid registration?
Then your lordship will come to the Act, Meghalaya Society Registration Act.
See, coming back to the analogy, suppose you have a car, you registered that car, right?
Yes, lordship.
And then you have suppose you have a commercial vehicle.
Yes.
You have a permit.
Yes.
Now the permit expires.
Permit expires, your lordship.
It expires.
No, there is a.
Please listen. It expires. You still have your truck, but you can't run it. It doesn't have a valid permit. That's the consequences of non-renewal of your permit.
Yes.
Now in the car societies, you're registered, fine.
Yes, lordship. Let me answer this question.
Yes.
In the in the Motor Vehicle Act and the rules itself,
Yes.
it is provided that penalty will be imposed. It has to be provided in the act or in the rules. So far this act is concerned, or so-called rules of my friend are concerns, there is no such penalty which is prescribed. Had it been prescribed, then the position would have been...
Okay, now your contention will be no penalty prescribed, no renewal prescribed also.
No renewal, your lordship. He has placed the...
No, you by your own.
No, your sir,
no
lordship.
That amendment is...
This is for the state, your lordship. That is why learned additional advocate general was directed by this honorable court to produce the relevant rules.
Yes.
Relevant rules. The relevant rules which has come before your lordship is an amendment by which Rule 3F is set to be inserted into the principal rules. Only on the face of it, he has just given me. On the face of it, I have found, and my duty is to tell the what I understand from the reading of the rule.
Oh, yes.
I have. It's not that it is my.
You've been very fair, even yesterday, by saying that even though the petitioner had obtained renewal, there's no provision for renewal.
Yes, it was going against me.
Yes.
It was going against me. But
what are the consequences?
The fact
That
is
why
this.
become next part of
The
consequences,
fact
not
is
renewal.
this. Then I couldn't get sleep in the night. I have opened my...
Those are the consequences of non-renewal.
No.
What are the consequences?
Then I got the Allahabad judgment. Allahabad judgment has taken me to the Supreme Court judgment.
Yes.
It has taken to the Arya Smart judgment. I found that even if once it is registered, it will lose its characteristic only when the provision, it is dissolved or registration is cancelled in accordance with the provisions contained under the Meghalaya Society Registration Act, your lordship. And moreover, if nothing satisfies my lordship, then petitioner number 2 is there.
You just see one thing is very...
Oh, and this is, your lordship, very important question.
It's a very interesting...
And a very important question. That's why I have taken little pain under the fact, under the circumstances in which I am placed presently. But nevertheless, your lordship, that...
the judgment is very good. I mean, I've not seen the judgment because it's a learning experience, I'm saying. But only thing is that what are the consequences? The penalty is by the registrar. But what are the consequences? You know, what relief?
It is for the state to provide, your lordship.
May it please your lordship.
Yes.
To the submission made that
I think we will do one thing. You want this court to render some kind of finding, you have to put your objections on
affidavit.
Yes.
And
maintainability.
in the meanwhile, my interest should be protected.
Lordship, to that I have
allow me. Don't be impatient, you know.
By saying, you know, one thing I'll tell you, Mr. Jindal, is just in conversation. Suppose you tell a person, please be quiet. That's like, you know.
No, I'm not telling
them
keep
not to
quiet.
be quiet.
I cannot say. At least I can tell to the Sulai.
It's like
I can tell to the Sulai, but I cannot tell to the additional advocate general.
Lordship, he was.
I cannot tell. I was his teacher, and I can.
That's human behavior. In human behavior, you say, "Let be quiet." That gives more reason for them not to be quiet.
I'm aware of my limitation. I'm aware of my.
I'm just saying that's a common human behavior.
So, Lordship, he has the right to say
quiet. That means that, you know, there is, only to a child, yes, maybe, but...
Your lordship.
Anyway.
No, lordship, being a Kuru, your lordship, he has the right to say.
No.
He has the right, he has the left.
Not to the additional advocate general.
Yes. Yes.
Lordship, that position is this, your lordship.
The merits of a case.
No, only for the purpose of getting this interim protection, because I have struggled a lot. Some protection should come. Your lordship, that position is there, that there is a work of construction of the veterinary hospital at Upper Shillong under the veterinary department. Now, there are ancillary works and there are main works. The total cost of the project is 63.20 crores.
How much?
63.20 CR. Out of this total project, the 17.30 is ancillary work, like construction of boundary wall and construction of internal roads, earthing and fencing. These are the small works, Your Lordship, small works. Now, we are the contractors associations, contractor associations who are small contractors.
Where's the tender document?
Pardon,
Page 19, Your Lordship. Page 19.
Writ petition.
62.
Writ petition thoda dena. Yes, please.
Only one page.
Now, yes, page 19. Now, 62.30 is the
Yes.
work,
Value of work.
and the earnest money is 62 lakhs.30, and the cost of tender document itself is 62.00. Now, this work of site development is the ancillary work which is I have stated in my affidavit. Your Lordship will come to page 5 of my writ petition. The petitioner.
So what you want here is that they should quit the work to allow small contractors.
Yes,
to do small work.
to do this, or to, because the work order is not yet issued. Work order.
It's already been tendered. The
Tenders are open, Your Lordship. Tenders are open.
Already been opened.
Work is not allotted. Work is not allotted, Your Lordship. And Your Lordship, because the tender has been structured in such a manner that it ousts the small contractor, and it has been deliberately made so. And Your Lordship, this has been the policy decision of the state government in particular and the nation as a whole to provide employment and generate employment to accommodate maximum number of people, Your Lordship. If the things are done in this manner, this will go against the policy decision of the state government to create the employment and to provide the employment to the local people. Here we are denied. Here we are denied, and our right to livelihood is also taken, and thus it is it places the small contractors and the big firms and contractors at par, and thus it is violating of Article 14. We have a right to carry on small business. Even Article 19 is attracted. 21 is also attracted because we are deprived of our livelihood, Your Lordship.
See, Mr. Jindal, when did you file this writ petition?
I have filed on 2. I think.
When you come so late, the general usual to June.
No.
Now it's already tender. July has already been open.
No, Lordship will just be.
Mr. V.K. Jindal,
Lordship,
council,
some relief till the next date, Your Lordship. Till the next date. Till the next date. Let them file the affidavit.
AG, with so and so is present on behalf of the respondents, no further notice required. Stop. In the instant matter, was fixed today for hearing on the question of maintainability in view of the fact that on the date that petition was presented for filing before this court, the British society was not in possession of valid registration certificate, in as much as the same was valid up to 21/7/2016. Stop. On this question, extensive arguments have been advanced by both the parties as to the maintainability of the petition, on the maintainability of the petition. And Mr. V. Kejan, Senior Counsel, also placed certain decisions which go to show that once a society is registered, it does not cease to exist as an entity, except an entity, and continues so until dissolved in accordance with the law. In accordance with the law. Mr. Endu Shulai, Leonard's AG has also advanced his arguments on the consequences of registration, as taken this court to the amendment rules dated
17/9/2012, Your Lordship.
2012, which wherein a clause 3.5 is inserted, which allows for renewal. So, be that as it may, as a question still remains open. The state respondents are directed to put in an objection of maintainability, objection on affidavit request of maintainability. Stop. Next paragraph. On the main merits of the matter, though the initial issue has not yet been settled, Mr. V.K. Jindal, the Senior Counsel, has submitted that some interim protection is necessary in view of the fact that the interim protection is necessary to protect some interim to protect the interests of the members of society who are small contractors, and for the state to consider retendering the work to allow the ancillary works to be carried out by the members of society. Stop. Next paragraph. What is your submission?
Lordship, my humble and respectful submission. Lordship, if Lordship kindly see, this is the tender, Your Lordship. It is a tender of public importance, Your Lordship.
Yes.
So my humble and respectful submission, Your Lordship.
The Council, AG, however, has vehemently objected to the prayer for interim orders, and has submitted that the matters of extreme public importance, and further, the tenders have since been opened on 3rd July 2026. It therefore submits that no interference is called by the stage. Now, next paragraph. On hearing the council of parties, this court deems it fit fit at this stage. Now that on hearing the council of parties, it is seen that as the issue maintainability is yet to be decided, the same is left open. Yes, to be said along with the main writ petition. With regard to the prayer for interim protection, it is noted as a tender since been opened. No interim orders are called for at this stage. This after
Not
2 weeks, Your Lordship.
one protection. Lordship, Lordship, just 1 second.
It's been open, we can't public.
No, Lordship, 1 second. But this may be made subject to the outcome of the writ. Any work order, Your Lordship, that can be, Your Lordship, I humbly prayed, Your Lordship. At least this observation that
Lordship, if they have a cause, Lordship, our civil court is there, Your Lordship, to claim for damages.
If I succeed, Your Lordship.
Just to add, yes, any further
work order
progress in the matter will be subject to
outcome of this.
The final outcome of the writ petition.
Highly.
Daily list item number 1.
Today, this is the series of disability lump sum, my lord. In 7 matters, they have
you
not
made a
filed
list?
affidavit in opposition.
Your Lordship.
Where the chart?
Your Lordship, our chart is ready, but Your Lordship, we wanted to enclose the medical records of the petitioners as well, Lordship.
No, I wanted a simple chart.
Your Lordship.
You can't just make a small column there for medical condition.
Your Lordship, but the
Where's Dr.
medical.
Motika?
He's on legs before courtroom number 1, Lordship.
Number 4?
Number 1. Lordship, I'm praying for some time, Lordship, so as to enable us to compile the relevant medical records, Lordship.
How many petitioners are here?
Items 1 to 5, 7 to 13, 15.
Items?
Lordship.
1 to 5?
Items 1 to 5, 7 to 13, 15, 17 to 24.
15?
15, 17 to 23, Lordship. These are all
16 out. 15, then 17.
17. 15, 17 to 23.
To 23.
Lordship. These are all lump sum compensation.
Lump sum compensability.
Lordship.
Yes. Now 1 to 5, 7 to 13, item 15, item 7 to 23. In these matters, Ms. American, then that Council Vice Dr. Mosikari, I praise that some further time be allow them to prepare comprehensive chart,
Lordship.
including the medical details of the petitioners.
Lordship, all the petitioners.
It will be the same, not objected to by Mr. V. Kumar for the petitioners. List of weeks.
Highly obliged, Lordship. Lordship,
My Lord,
item number 6, it pertains to a different subject matter, Lordship. Here we have to file an aft.
6. Item 6.
Here we
my Lord, item 6 pertains to the reading entries, my Lord. Some record is asked
We've
by the
received
petitioner, but
Parawise,
affidavit in
Lordship.
opposition has not filed.
We've received Parawise, Lordship. I'm praying for some time.
Yes, as create in this matter, Nakajongani, further 3 weeks time, allowed for affidavit.
Highly obliged.
Then
My
16.
Lord, deep your Lordship. 6.
16.
Next time, you want to write something in this Haju. The next was this.
May it please your lordship.
Yes, appointment been done.
Appointment has been approved, your lordship, but appointment order has not been
Close it,
issued.
Mr.
because-
Order has not been.
You tell them to issue appointment order within 1 month.
Your lordship, we are awaiting a police verification. The petitioner has to submit a police verification.
Is this under process of police verification? That is
order. Yes, on the last date, that is 36/2026. MSZE non-country learned GA for the state respondents had submitted that as per instructions received, approval had been obtained for appointment of the petitioner to a suitable grade 3 post. Today, he submits that the issuance of formal employment orders is awaiting the receipt of police verification report with regard to the petitioner. So, on this submission, the Sarnath prays that the matter can be closed by directing that the appointment orders be issued preferably within
15 days.
Within 4 weeks, yes. Accordingly,
Your lordship,
matters are
that will be subject to the submission of the application.
Here's the procedure.
Accordingly, the matter stands for direction that if the police verification is report received within a period of 4 weeks, the appointment orders should issue.
14.
I love this.
14.
Matter stands this process.
14.
14 confirmed. Wait, yes, where's Mr. Esteb? You're for 4 and 5.
No, your lordship, I'm for 1, 2, 3, 6, and 7.
Whose eyes imlay for 1, 3, 6? Oh no, 4 and 5, yes.
Lordship,
Where's the
filed our affidavit already. We are waiting the rejoinder.
Where's Mr. Deb? Stop. None appears for the petitioner nor any rejoinder filed to the affidavit filed by respondent 4 and 5. In the interest of justice, last opportunity of 2 weeks allowed for rejoinder. Just thereafter for further orders.
24.
The ACR for the period of ERE duty
Where's
has not
affidavit?
been taken
Lordship,
into
we've sent it for signature, Lordship. I'm
Let
praying
them put
for
an affidavit on record
10
and
days
dispose
time,
of.
Lordship.
Mr. Kumar, Ms. MS Mbarichang, the counsel by Dr. N. Mojika, so and so. Submit the affidavit ready, will be filed shortly. Just after 2 weeks. Yes. We'll dispose of then.
Lordship.
my lord. My lord.
25.
Deeply lord.
Yes.
My lord,
Yes, Mr.
notice has been served, completed. Now for admission hearing, next date may be fixed. My lord.
Hello, NHIDCL is a.
Been for number 5.
Yeah.
Answer the state, my lord. Mr. Pandey was supposed to appear today, my lord.
Who?
Mr. Shankar Pandey. He informed me he has instructions to appear in this matter. So we'll have to call for a fresh inquiry, spot inspection.
One second. Okay. Yes, Mr. Elam Sama submits that service has since been affected on respondent number 5.
Yes.
However, there's no appearance on behalf of the respondent today. And what is submissions next one?
We have to call for a spot inspection, my lord.
It is already inquiry made, your lordship.
I've gone through the report, it's not conclusive.
Which report?
There is a report, my lord, which is
Submitted by BDO, report already is there, my lord.
at page 24. There is no indication of the chainage from where to where the inspection has been conducted. Because the original case is that there was a certain alignment which was drawn up by the state as well as NHIDCL, and there has been a deviation by the NHIDCL from the original survey. So they claim that the original surveyed area has been completely ignored. They've been paid for that, about 21 lakhs. And now there's been soil dumping and some of their trees have been affected, and additional part of the land has been taken over by virtue of a new alignment.
And the land acquired from them be given back to them?
No, it has not been given back to them. So therefore, we need to conduct a fresh spot inspection.
Mr. SN.
But it is affected because of soil dumping and all.
Yes?
Yes, sir.
Affected by soil dumping?
Dumping.
Yes.
Even betel nut and all destroyed.
Submits that the report, which is annexed to the petition on examination, appears to be inconclusive. But he submits that perhaps a fresh inquiry maybe have to be gone into stop. He prays is allowed to receive instructions before the next date.
Yes.
Yes, this after 2 weeks for instructions and for appearance of the respondent number
5.
5, yes.
Obliged.
Highly obliged.
You come instructions whether you do it fresh or not. Yeah.
26.
26 minutes, we are filing the affidavit in the court.
Brahmatra, why products?
Bullets.
You're for the lawyer?
I'm for the petitioner, bullets.
You filing in the course of the day. You receive the copy?
No.
Send that.
We will serve them a copy.
Yes, Mr. S. Pandey, Leonard Counsel for the respondent corporation, submit the affidavit will be filed in the course of the day. Just after 1 week. And of any.
Obliged.
27.
May I please, Your Lordship? We already filed the rejoinder, Lordship.
We received the rejoinder yesterday, Your Lordship. Your
Ready
Lordship,
for hearing today.
let this matter come up to 2 weeks, Your Lordship, for hearing.
Yes? Yes, parties submit the proceedings are complete. It is a matter of hearing on so and so. Yes.
28.
Candidate 29, affidavit in opposition is still awaiting.
What's the matter about?
Item number 28 against the discharge order, my lord, and item
When
number
was he
29
discharged?
is the promotion. He was discharged from service on 13/9/2025, my lord, on the ground of the own request, my lord.
I'm praying for some more time, Lordship. We're yet to receive instructions.
Yet to receive instructions?
Lordship.
Okay, as prayed for the 3 weeks time allowed affidavit. Same order in 27? 29?
8 and 29.
Yeah.
29, my lord.
Obliged.
20 in the promotion matter, my lord.
30.
Deeply your lordship.
Wait, please, Your Lordship. Your Lordship, I'm praying for 1 week's time to file our affidavit.
The fresh matter?
Yes, Your Lordship.
Not really so fresh.
It's filed in March, Your Lordship.
Yes. What about the pension matter?
Yes, yeah.
Your Lordship, it's actually for correction of date of birth. The petitioner was supposed to retire in the month of December 2022. And then she was allowed to serve an extra 8 months, Your Lordship, because she had made a case that her date of birth was wrongly reflected.
8 months he adjusted.
Your Lordship. I'll file an affidavit, Your Lordship.
When will you file it?
I'm praying for a week's time.
Amazon every pays funds allowed further 1 week's time to file. Affidavit. None appears on behalf of the respondent number 6.
6 and 7, Your Lordship.
31.
Your Lordship, in this case, we're praying for 2 weeks' time to file affidavit, Your Lordship.
Where's the petitioner?
And for the petitioner, Lordship.
Yes. I've prayed for the 2 weeks' time allowed for affidavit. Yes, thereafter. So.
32. 32.
Yes, my lord. I have received one counter affidavit from respondent number 4 and 6. The rest have not filed yet.
May it please your lordship, I'm for 1, 2 and 3. We'll be filing our affidavit in the course of today.
What about 5?
I'm appearing for respondent number 5. Your Lordship, some documents and instructions yet to be received. So I need 2 weeks' time, Your Lordship.
What's the matter about?
This is a land acquisition matter, my lord.
matter. Question of ownership of right land, lordship, and payment of
You are appearing who's 5 is whom?
Respondent number
5.
5 is the headman, my lord.
Headman.
4 and 6?
I'm appearing for behalf of
Sardar.
You are?
already filed.
So you file affidavit? Yes.
I'll file a rejoinder, my lord.
Mr. ASD, then Council 1 to 3 submits the have to be filed the course of the day. MSD Timum
Yes, you are.
for 5. How much further time?
2 weeks' time, Your Lordship.
Why delaying? These ones are further 2 weeks to file. Expected next year the affidavit should be on board. Yes, list thereafter
2 weeks, my lord.
2 weeks. After 2 weeks is for the order. Yes.
33. Oblige.
Yes.
Your Lordship, I'm praying for 2 weeks' time to file our affidavit.
Why? How many times you sought?
This will be the 3rd time, Your Lordship, after motion.
No objection.
Any urgency?
Lordship, the money has already been recovered back by the state respondents. There's a substantial amount. Yes, Your Lordship.
I'll just aspirate further 2 weeks allowed for affidavit.
Much obliged.
34. 34.
Well, the affidavits are awaited from the respondents.
Lordship, I'm praying for some more time, my lord. File the affidavit.
You're appearing for number?
I'm appearing for respondent number 4, my lord.
And what 1, 2, 3?
My lord, I'm appearing for 1, 2, 3.
1, 3 is what? It is.
KHDC, my lord.
Why no appearance last date?
My lord, I missed out this matter. I
Too
was
busy.
in a different court.
Only 4 respondents are there.
Lordship, there's a private respondent 5.
You served.
Lordship, we had taken steps, liberty to serve by Dusty. There's some communication gap with the.
No, but you were out last week.
Lordship, so far as that Dusty.
You issued by Dusty.
Lordship, we are yet to take steps because there's some difficulty with the Sardar, Lordship, with the petitioner. He's out of station, so we are not able to take steps. Otherwise, the notice is ready.
Yes, MS. You'll file affidavit.
Yes, my lord, I will.
MS OI Bank 1, 2, 3. Submit after. Praise allowed further.
My lord, it's 2 weeks' time. My
And
lord, I
file
have complete
affidavit.
instructions.
Similar prayer made by MS NG Shilla for 4. With regard to number 5, Ms. Emma Lumkur submits that fresh steps will be taken.
Fresh steps, Lordship.
Will be taken for service of notice. Yes. This after 2 weeks. Yes.
It can come after 3 weeks, Lordship. I'll also file the affidavit of
It'll be
service.
3 weeks.
3 weeks.
Okay, just about 3 weeks.
Very good.
35.
May it please your lordship.
Yes, Mr. Nompu.
I'm praying for some more time, lordship, to file an affidavit.
Affidavit is awaited in this matter.
Must be whole truckload of affidavits which have to be filed.
Yes.
Yes, wait for a 3 weeks time allowed. Yes.
Obliged.
36.
Milord's, in item 36, affidavits have been filed by Milord's respondents number 5 and 6.
Number
5 and 6, Milord's.
Yes. What about 3 and 4?
We're not finding much.
Okay, what about 8 and 9?
9 requires some more time, Your Lordship.
Why?
No, still awaiting instruction.
You are paying for 5 and 6?
5 and 6, yeah. Lordship, yes.
Yes. Number 7?
7, Milord's not served. We'd have to take fresh steps on respondent number 7, Milord's.
Yes, not yet. Yes. Mr. T. Marangar. What 1 and 2?
1 and 2 is the state, Milord's.
Not the state. Yes, none for 1 and 2. Any interest to file affidavit? No. Then how you putting 1 and 2? You have no instruction. What's the matter about Mr. Paul?
Milord's, here the matter relates to Milord's alienation of certain lands in the face of orders passed by this court, Milord's, whereby there was a dispute, Milord's. It came before your lordships. Your lordships dealt with the matter, Milord's, remanded the matter to the district council.
The government has nothing to do with it.
I'm sorry, Milord's.
State has nothing to do with it.
MIDC is there, Milord's. I don't know.
MIDC is a
Milord's,
autonomous thing.
Milord's.
You are paying for MIDC. Then you say 1 and 2.
2 is MIDC.
You have to serve separate notice.
Well, it's the Advocate General had appeared at one occasion, if I remember correctly.
Yes, MS Islalu, you have no idea.
No, AG had appeared for respondent number 1, Milord's. I stand corrected.
Okay, yes. MS Islalu present, we have respondent number 1. Submits that no affidavit before coming as a respondent. Stop number 2, it appears is number 2. With regard number 2, petitioner will require. No, MIDC is separate. Will to take steps on number 2.
Milord's, 2 is served, Milord's. They've appeared.
Served.
Yes. 2 is served, Milord's. Mr. Kharwan Lang had appeared for RR 1 and 2, Milord's, on 3/6/2026.
Where's Mr. Kharwan Lang? Okay, then.
I may be allowed to take instructions from.
Oh, you appear at MIDC normally. Then who will appear in 1 and 2?
I haven't received any instructions, Your Lordship, for number 2.
Oh, no. Somebody he has no instructions with regard to respondent number 2. Stop Mr. MSPS number 3 and 4. Submits a no affidavit forthcoming from said respondent. Stop. With regard to 5 and 6, affidavit been filed.
Yes, sir.
It's been filed.
Milord's. 5 and 6 are filed.
You are Mr.
PL Sokmi.
PR Sokmi.
PL Sokmi.
PL Sokmi for 5 and 6 submits that. Affidavit has been filed. Mr. T. Marangar also with a prayer for further 2 weeks time to file affidavit.
In the meantime, I'll also take instructions.
Yes, for instructions and affidavit.
Obliged.
37.
Just taken decision.
Slight difficulties. My lord, what happened in this case, my lord? I just got the news, my lord. I do not know the details. This has been further deferred. But when is the next day? I do not know for the reason, my lord. The law officer, she's on bereavement. Her nephew died. The
law officer?
Law officer of the university. Which normally she gives the instructions.
When is the elections?
Not yet notified.
Not yet notified.
Not yet.
But as per the rule, it's supposed to be conducted within 6 months of
Do you
demise.
have any substitute candidate ready?
No, I'm the only candidate.
My lord, if it come up after a week, I think we can.
You're the only candidate.
I'm the only candidate already nominated.
No, there should be no harm. Why this
Yes.
matter?
My lord, let a direction be given
Direct them to.
within 1 week, my lord, to.
Yes, Mr. SN today submits that though the Executive Council was supposed to meet on 14/7/2026, he has no instructions as to the outcome. Stop. Outcome stop. Review the matter after 1 week.
Lordship, I'll please tell you.
For the audit.
All right.
38.
In this case, Your Lordship, we've received instructions. We just need 2 weeks' time to prepare and file the affidavit.
Yes. has prayed for the 2 weeks time allowed for affidavit. Just after.
39.
Please, Your Lordship. I'm praying for some more time, Lordship, to file an affidavit.
No objections.
This is a fresh matter, yes. Further
No
2 weeks time has prayed, yes. Allowed that.
40.
Highly.
Let's, I'm instructed, we're required to file an affidavit.
Yeah, but that was supposed to be on board today. I think
We could not file it, because of some translations were required. We're praying for a week's time for that.
See, we also expressed we're not inclined to interfere. It's just that its internal matter should be.
Well, it's
My lord,
Mr. Shongwan, he
my
made very
simple-
strong submissions last time. Oh, he's there. Yes.
my very small submission would be, my lord, your lordship kindly see whether the order passed by the DC can exist even for a second. Now he has transgressed into the constitutional violation, my lord. The constitution has given us the power. My lord, I will just take your lordship's Article 26.
No, Mr. D, let them file affidavit. We'll dispose of next year.
No, my lord, even then, your lordship kindly see,
We have
if
seen
they
that
file an
last time
affidavit,
also, the only thing that eminent situation at that point of time was that there was, that Holy Sacrament.
The sacrament was to be
given that. So now, if we can finish it, we just exchange your pleadings, we'll dispose of
no, that's all right, my lord. That's a different issue. They can file it. There's no problem in. But then just I will take your lordship to the impine order, whether it reflects that there is a disruption of public order, morality, health, all these things. And once they can satisfy, the DC can pass an order. And failure of all that thing, my lord, he cannot do any other thing, because can a constitutional right can be taken away? Even by legislation, one cannot do that. Therefore, my lord, your lordship, just for a while, I'll just take your lordship to Article 26.
Yes.
That speaks, my lord.
Yes.
As your lordship got it.
Yes, yes.
Freedom to manage religious affairs, subject to public order, morality and health. Every religious denomination or any section thereof shall have the right. We are concerned in regard to B, to manage its own affairs in matters of religion. Now there is no rider, my lord. Then your lordship kindly see C and D. To own and acquire movable and immovable property, and this is important, to administer such property in accordance with law. Now in regard to, my lord, management of the affairs in relating to the, my lord, religious formalities, this is absolutely with the religious authority, my lord. No one can interfere, even there cannot be any legislation to that. My lord, C and D, there may be legislation, but so far my knowledge goes, the state of Meghalaya hasn't enacted yet. Now, in that view of the matter,
Let them manage. You all manage on your own. That's the only thing. That is why this court also will not, be weak to cause any interference. That's the only thing.
right, and your lordship will not go into all that, because
Not going to go to all that. Yes.
under sitting in 226, your lordship cannot decide it. It's a matter at best.
That is already expressed last time also.
Obviously, my lord, at best the civil court has the power to go into all this.
That is why, yes.
Now, your lordship kindly see for a while, we have been stopped to do everything, the religious function and all that. Now,
You want to
how,
argue
where that power has
You want
come?
to argue on interim orders?
No, my lord, I am pressing this because your lordship kindly see the order passed by the DC. Can he, my lord, the DC, my lord, he has the power to say that you do not have the constitutional protection. And there is, in this order, your lordship kindly see at page 118, there is no reflection relating to, my lord, whether there is disruption of any public order and all that. There is a total absence of all these ingredients.
You see, Mr. D, in para 8 of the last order also, or passed by this court.
Right.
You kindly notice, only legality impugn orders will examine that. Let them file affidavit and we'll hear it. Post of admission hearing,
My lord, can your lordship give a very short date
Yes,
so that
we are always here. We're not on vacation.
because your lordship kindly see what is happening to the chart. They can't do anything, my lord. And under the order of the DC, my lord, which it is totally without jurisdiction. An order passed by a DC, if he doesn't have any power to do that, can he pass such an order?
Also, you can't. You have to get the fact you have already within the entire organization hierarchical structure. We have internal dispute resolution mechanism also. We have a constitution. So those are the things which the court will not be quick to enter into that arena.
No, I will not take your lordship to do all that also.
To see, in fact, the executive authority within the the legality of the orders. That's all.
No, that can, my lord.
So you fix up admission hearing. You take a date, then you just
Let me after 10 days.
you file affidavit.
We'll file our affidavits within 10 days. Any
After
date
10 days,
that.
your lordship. We'll also file the.
Mr. Shongwan, you'll file affidavit also.
My lord, in regard to this religious ceremonies and all that, we may be allowed to continue to do that.
They're doing it. Because my instruction is.
In that
as
case,
a
my
matter
lord,
of fact,
if we are doing it
this
very
entire
good.
matter has become infructuous. Why? Because your lordship will recollect the dispute revolves or rather emanates from a certain pastor who was deordained. After the entire fiasco before this honorable court, where we took the considerable judicial time and your lordships had to deal with it till 4:30. I am instructed, the person who's been deordained by the church was allowed to hold the sacrament.
By whom? By you?
The other group. By the
My
petitioners.
lord, supposing, my lord,
Such is the state of affairs.
My lord, supposing we are violating the disease order, my lord, we can do that. My lord,
Not a question of violating
this is order. The order of the DC is without jurisdiction, and the Supreme Court has said.
Why did DC, your lordship? Because they are complaining and complain and counter complain, your lordship. This has to step in, your lordship.
No, under what circumstances?
Before stepping in, also, your lordship, we sought the view of the
Ideally, what has fallen from your lordship, there is a mechanism that is provided under the constitution of the church itself. That has to be explored.
No, that is okay, my lord. I am not going into all that. And being a reed court, your lordship cannot decide all that thing, because those are the questions where, my lord, the question of evidence and all that will come. So therefore, ultimately, my lord,
Mr. K. Paul today prays that he will have some further time to put this
10 days.
affidavit stuff as the matter requires early disposal. 10 days time is allowed for affidavits. You want to file a reply thereafter?
I don't think it will be necessary.
After 10 days,
this the matter.
Well, after 7 days.
DC also would like to file the affidavit, your lordship.
10 days. As a fixed matter for admission hearing.
Lord, yes, highly obliged.
And your lordship will, my lord, all endeavour may be made to dispose of the entire matter.
It depends on the council. The court's always here.
My lord, your lordship, can a date be fixed?
Mr. Shongwan also for a
State also, your lordship would like to put, because they are
Mr. N.D. Shulai on behalf of the state and also
they have to so much against the
similar
state,
time to put in the affidavit.
We are
Yes.
not against the state.
highly obliged, your
My
lordship.
lord, a date may be fixed.
Yes, you take court master 10 days. Yes.
Much obliged.
That's why there's a court master. They master
Yes,
the
yes.
dates also, not us. Yeah.
My lord, in our place is something else, as your lordship say where.
Second call from supplementary list, item number 1.
Where Dr. Mojika is still on legs.
He's still on legs, lordship. Lordship, I'm praying if it may be taken up after exhaustion of the hearing list.
Out of exhaustion of hearing list.
Lordship.
Okay. After hearing. After some time again.
Two.
Two also.
Two also, lordship.
Two, Mr. Number notice.
It's a covered matter, lordships. It's for
very thick petition list.
Because there are 600 petitioners.
How many petitioners?
664 petitioners.
How many pages is the cost title?
It's about 100 pages. Cost
And
title.
how many pages the body petition? 3 pages.
No, 6 to 8 pages. Lordship.
How come these people escape the net? Earlier on, they didn't come to court.
No, they have not.
They come with same 2000.
No. These
1998.
no. These
Those
pertains
orders
to
53.
no. These pertains to first financial upgradation, lordship. These are the third batch. So in those 2 repetitions, your lordship has already allowed the repetition, and since the orders are not complied, a contempt is also pending against. So I'm praying if this
So not
matter.
complying because of the financial implications. That's all.
No, they said that they had placed the matter before the MHA.
Let's see, yes.
Lordship, if I pray that this matter can come up on 3/8/2026, along with the contempt matter, Lordship.
Will issue notice.
No.
Heard Mr. Emerald General Counsel for the petitioner issue notice. MS Emerald Chiang, General Counsel by South and Bozika is present, except we have all the.
No.
I can't even find your first page of the petition.
Lordship, there will be a page. It's from
Page?
Page 97. Lordship.
Okay. On behalf of all the respondents for those required, list on 3.8
Lordship.
for instruction the affidavit. Yes.
Lordship, just one more submission, Lordship. So far as petitioner number 424, Lordships. So, Lordships, I have instructions that he does not want to pursue the matter at this stage right now. So he wants to be withdrawn, Lordship. Petitioner number 424. Lordship.
Yes, Mr. Emanabal also submitted that 424 to respond number 4 petition will be struck off from the list of parties.
Lordships.
Yes, as he is not willing to pursue the matter, but he has allowed this.
At this stage, Lordship, because at this stage, because he might fail.
He is to strike off the said petitioner from the list, from the array of petitioners. Yes.
Khalib.
3.
I apologize, Millets is not here in the morning. I'm instructed, Millets, that your Lordships, what has come from the corporation is they're saying 1 crore. Difficulty, Millets, I had expressed to you, my Lords, I have to pay the money. Millets, I am also giving an undertaking before your Lordships. Millets, I cannot be in violation of that undertaking. Millets, it's like this. Because they are saying, Millets, if I may just explain myself, your Lordships, just bear with me for 2 minutes. Millets, they are saying 4 installments. I am agreeable to the 4 installments only, Millets. I am only saying only the first installment, Millets. Let it be in 2 tranches. That's all.
That's 5 installments then.
No, Millets. It's because I don't get an extra period of time. I don't get any extra period of time, Millets. They were saying, Millets, that the first installment should be the entire amount of 1 crore 80 should be upfront. I am saying, Millets, I don't have that kind of money.
By when are you supposed to pay that money upfront?
Millets, they were saying,
where is the schedule of payment?
Millets, what they have stated before my lords is they had stated, Millets, that the upfront payment of 1 crore 80 lakhs 23,473, meaning, Millets, that I paid today, then tomorrow they will reconnect. I am saying, Millets, let me pay the 50 lakhs, please reconnect, and then, Millets, 1 crore 30 I'll pay it.
No, it'll be after every month. What is the schedule?
Schedule is, Millets, 4 installments.
4 installments means
of 1 crore 80.
No. Where's the periods between installments? How much?
1 month, Millets.
For 4 months.
For 4 months.
So it was a very fair offer, but the situation is that the corporation, the petitioner is not willing to accept that.
Millets, if I may, my friend may then come in. If your Lordships just permit me. Millets, the corporation has a due. They say, Millets, 6 crore plus is due from you. I am acknowledging the fact, Millets, that 6 crore plus is due from me. You are telling me, Millets, you pay it in 4 installments. I said, very well, I'm paying it in 4 installments.
You're submitting this. Same submission immediately, same thing again.
Millets.
Only thing is that they not also instruction.
Millets, which is why I prayed before your Lordships, Millets, and if your Lordships would recollect, Millets, but at some point of time, my Lords were passing the order. That's when my learned friend said that kindly give me some time to obtain instructions. It had also fallen from your Lordships, my Lords. We're not trying to bargain here. I am, my Lords, expressing my genuine difficulty. If I had the resources, my Lords, there is no problem in paying it. Now, insofar as the corporation is concerned, my Lords, if I were to place myself for a minute for the corporation, my Lords, the corporation is interested in the installment of 1 crore 80, my Lords. If I pay it in 2 installments, what difference?
Can you pay after 1 week?
Well, it's within 3 days from today, we are paying 50 lakhs.
Okay, 50 lakhs, and once reconnection is done, when can you satisfy the 1 crore 1.3 crore?
Just bear with
the first installment.
Because the difficulty, because this matter traveled till the Supreme Court on the very same issue. The Supreme Court refused to grant any latitude to the petitioner, my Lords.
See, Mr. Pandey, we are alive to the issue. You've seen this is
my Lords, the difficulty here is, my Lords, what my friend is saying, part of the thing. What my friend is not saying, my lords, that thereafter they allowed 7 installments and the entire money was paid off in 7 installments.
Yes, what is the substance? Sorry?
My lords, my instructions are, my lords, 50 lakhs will pay within 3 days, my lords. Only after repayment, let them reconnect the electricity, my lords. And in terms of, my lords, when the installment falls due, I will pay the 1 crore 30 in addition to my current bills. I am not asking for any further latitude.
We'll fix it this way then. Mr.
My lords may keep the matter alive before your lordships, so that, my lords, your lordships are conscious whether I am paying the money or not.
Yes. That's what this court is going to observe.
My lords.
We'll keep the matter pending. Let them deposit 50 lakhs within 2 days.
Because then it should not be upon the respondents. Can order.
It's falling for my lords.
It comes from the court. Yes.
It's coming from the court.
Yes, Mr. S. Pandey, Ms. S. Pandey, on instructions today submits that the respondent corporation is only willing to relax the amount payable to rupees 1 crore. He has to be paid upfront and for the reconnection of electricity to the plant of the petitioner. Stop. Other conditions submits will remain, should remain the same. Next parameter, Mr. K. Paul Senior Counsel has however submitted that the petitioner is in dire financial straits and undertakes before this court that if allowed to deposit a sum of rupees 50 lakhs within 3 days and reconnection be effected thereafter, the petitioner will abide by and honor the payment, honor the payment of the remaining amount within 4 installments thereafter.
4 installments as proposed, my lord. So as proposed by the corporation.
As proposed by the respondent corporation. Though this offer and counter offer seems to work at cross purposes, however, in the interests of justice and in view of the solemn undertaking that has been given by the counsel petitioner in the presence of the managing director of the company, Mr. Adarsh Jhunjhunwala.
Present,
Mr. So-and-so is present in court today. This court directs as follows. Stop. The colon dash 1. The petitioner shall immediately within a period of 3 days from today and not later. Today is 15th.
Well, today is the 15th.
Not later than 18th. 3 days.
16, 17, 18th, yes. Saturday.
18th shall deposit amount of 50 lakhs before the respondent corporation, who shall then cause reconnection of power / electricity to the plant stop. Thereafter, as proposed in the
Melody, may I? I'm sorry to interject. May I just make a small prayer? Rather than any further directions flowing from your lordship,
as for the letter,
I am only saying, Melody, at this stage, let me pay the 50 lakhs. Let the power be reconnected and the matter come before your lordships, my lords, on the 21st or 22nd, so your lordships can verify my bona fides.
No, there are no bona fides.
No. We are latitude, enough latitude. Yes. No. Sub 2, on such reconnect, the balance amount of first installment shall thereafter be satisfied not later than 10th of August 2026.
That's
and the three remaining installments per balance amount on or before the 10th of every
10th of September, October and November.
10th of every succeeding month thereafter. To also ensure the faithful compliance of this court's order, the matter is not disposed of and kept pending.
Pending.
Yes.
Well, it's only one prayer.
Yes.
Because this leads to further confusion, Millet. It leads to confusions. In my Lord's orders, your Lordships may just kindly quote the figures, Millet, as is there from there. 1 crore 80 23 473.25 Millets. We'll give the figures to the court master, Millet, sir. So that the figure is very specific.
The figure
verified who's appearing for the.
What is remaining?
You see, this only the first installment. They'll be small. It'll just be 1.3 crores. But then the rest will be.
No, first installment will also be Millet's 1.8 only. It's just that Millet is giving it in 2 tranches.
Yes. Next.
Obliged.
Just may consider noting one thing, Millet, my objection to the maintainability of the petition may be recorded.
Okay.
Yes. That may be noted.
Yes. My Lords would have it at the end of Millet's the 4 months. The matter is kept alive, Millet.
No, we'll have it on the 10th of August.
Keep it
No, that's what that's what. Let it be on the 11th of August, Millet, because that 11th of August is Tuesday.
Yes.
So by then the compliance would have been there.
Yes. Or we'll hold you up for contempt and take you straight to jail from here.
Only reason, Millet, why I requested for the figures to be incorporated is, Millet, then we see sometimes what happens is we pay the figure as is there in the letter. Then they will say that you've paid this, but you've not paid this. So let the figure be very specific.
Yes.
Supplementary list item number 1.
Please, Your Lordship.
Yes, what is this?
Not. This is a.
This matter is pending and put other matter.
It's a contempt. Contempt is pending. We have filed a contempt, my Lord.
What is the why you file a fresh petition then?
Well, what had happened is that by virtue of the letter dated 27th April and 29th June, a fresh inquiry department that will be, my Lord, at Annexure 6, page 94, 95, my Lord. My Lord, Annexure 6, type copy is page 95. In statement and service,
page 90?
95, my Lord, that's a type copy.
95. Which one?
My Lord.
Yes.
In statement and service for disciplinary proceeding, RO number so and so.
Copy, please, sir.
My Lord. Number 1, copy of previous department C and I complete by 44 AR along with Honorable High Court of Meghalaya Shillong White Judgment dated 13 November 2025 in rate appeal number so and so. Are enclosed herewith. Number 2, you are requested to forward your appropriate reply within 30 days on receipt of the said letter to this office for a further necessary action, please.
Yes.
This is the first letter, my Lord. Then your Lordship will come to Annexure 9, page 110.
What does the order say? Last order?
Last order. My Lord, the order, your Lordship, there are 2 orders. If your Lordship come to.
What is order 13 November 25? What's the
13 November, my Lord, will come to page 5, paragraph 5, my Lord. Page 5 on married petition, my Lord. Page 5. I will already reproduce it, my Lord. Paragraph 5, my Lord.
Yes. According to the appraisal supply copy.
Yes, my Lord.
By report. Yes.
24-25 is very relevant, my Lord.
Yes.
Accordingly, we direct the appellant to supply a copy of the inquiry report upon the writ petitioner within a fortnight from date to which the writ petitioner shall make detailed representation within 4 weeks thereafter. 25, my Lord.
Yes.
The disciplinary authority is directed to conclude the proceedings, preferably within a period of 3 months from the date of submission of representation by the writ petitioner. The writ petitioner shall be reinstated only for the purpose of completing the disciplinary proceeding and shall be entitled to the subsistent allowance as per the extent rules from the date of the order of dismissal, that is on or from 23/5/2014 till the proceeding are concluded. All, this is very important, all the areas towards the subsistence allowance shall be paid within a period of 4 weeks from the date, and that shall be a condition precedent before any further proceeding can be initiated for conclusion of the disciplinary proceedings. In the event the subsistence allowance is not paid within the aforesaid period, the impugned order shall revive, my Lord.
Yes.
So, my Lord, this order is very clear, my Lord. The subsistence allowance was never paid to me till date, my Lord.
Really, Dr. Mazika?
Yes, my lord.
Not paid.
That your lordship will find. We have placed a communication in the contempt, my lord, saying that the bill has been raised, my lord, but the amount is not been paid. 4 weeks, my lord. Within
Then
4
order of division bench is there. Then we'll stay this. How can you?
Bring for
How
stay
can
this-
you?
Yes, ma'am.
Yes, sir. Heard Mr. El Karim, then consider petitioner. Issue notice. Dr. Mbuzika with Ms. Ember Chang is present on behalf of respondents 1 and 2. No further notice on these respondents. Stop notice to issue for number 3 within 3 days. Stop the grievance of the petitioner. But in spite of the directions of this court,
Still there.
for reinstating, for reinstation, and for clearing the backlog of substance allowance and other payments, the respondents by order dated 27 April
2026
have
and memorandum dated 29/6/2026.
though reinstated the petitioner service for these proceedings, have not complied with the order dated 13 November 2025 passed in WA number 6 2025. We therefore praise that the proceedings being initiated, the fresh proceedings being initiated, being in violation of the orders of this court itself, the same be stayed in the interim. Dr. Mojika for the response praise without to obtain instructions. Yes.
File affidavit.
According to this matter, after 3 weeks, construction affidavit stuff. As it is seen that Ram Fasai case has been made out for interim order at this stage, it is provided that the impugned letter dated 27/4/2026.
The proceedings will be stayed, my lord,
Yes.
the memorandum.
It is provided all further proceedings against the petitioner shall be stayed in the interim until the next date. Yes.
Pursuant to memorandum dated 29/6. Pursuant to
Yes,
memorandum dated
pursuant to memorandum
29/6.
dated
29/6/2026.
29/6.
Memorandum.
Yes. Yes.
Obliged.
Hearing from daily list item number 41.
Huh?
Where is the book? Well, this is that matter your lordships will recollect, well, it's where the expression may and may not are to be interpreted by my lords. Well, it's what we found in this is, my lords, I had already made some preliminary submissions before your lordships on the last occasion, my lords.
That's only the petition of that.
May not, my lords, has to be read as shall. The reason being, my lords, it would be a absolute absurdity, my lords, if we had to say that I'll take your lordships to the provision again.
Yes.
Well, my lords would find it at page 17, my lords, of the writ petition. Last 3 lines of, my lords.
Appellant,
appellant complainant, as the case may be,
any person
may seek the assistance of any person in the process. So it says first, my lords, there are 2 parts to this. May seek any person.
Yes.
In the process of the appeal while presenting his points, and the person representing him may not be a legal practitioner. So my lords, there's a larger thing that is permitted saying that you may appoint anybody, but he may not be a legal practitioner. Now, what we are submitting before your lordships is, the moment the expression may not is used, my lords, that therefore has to be a negative injunction, which says, my lords,
but
it shall not.
How can you read shall? How can you read
My
shall
lords,
to me now?
the law, and I'll place the law before your lordships. I'll place the law before your lordships. Because, my lords, it says you may appoint anybody, but he may not be so and so. So it is a sub-qualification within the larger qualification. My lords. Coupled with the fact, my lords, what I had opened my submissions before lordships with is the fact that right of legal representation in these matters, my lords, is not an absolute right. It comes with certain fetters. So then your lordships would then have, my lords, the first closest example that we can take your lordships with, my lords, is if your lordships kindly have section 12 of the Indian Contract Act. If the law requires, my lords, then your lordships will go back to the intention of the legislature. If my lords kindly have section 12. My lords have it?
Yes.
My lords, I'll read this, so this will clarify what may not means, my lords. What is sound mind for the purposes of contracting? A person is said to be of sound mind for the purposes of making a contract if, at the time when he makes it, he is capable of understanding it and forming a rational judgment as to its effect upon his interests. A person who's usually of unsound mind but occasionally of sound mind may make a contract when he is of sound mind. Your lordships have seen these two expressions, both are may. Then your lordships may kindly come to the third part. A person who is usually of sound mind but occasionally of unsound mind, then, my lords, the legislature inserts, my lords, may not make a contract when he is of unsound mind. So, my lords, therefore, my lords, the distinction between may and may not.
Yes.
So, the larger premise is, my lords, you can make a contract, but during the period, my lords, the sub-classification comes in. During the period when you are of unsound mind, my lords, you may not make a contract. That cannot be interpreted, my lords, what has been argued by the learned Advocate General before your lordships, that it is may. So I may or I may not. I had also submitted before your lordships on the last occasion, my lords, and your lordships has taken note of it. My lords, a popular expression that, my lords, is used in court. My lords, there are various times where we say, my lords, may I read this or may I place this? Your lordships sometimes revert as, my lords, yes, no. But your lordships may also say, you may not.
Yes.
Whether that would mean, my lords, I still may. The moment, my lords, the may becomes qualified with not, my lords, it becomes a negative injunction. The moment it becomes a negative injunction, my lords, then it cannot be interpreted as there is any discretion that is left open.
Okay.
Where is the judgment first? Huh? My lords, one authority that we found on close to this issue, it's a Constitution Bench judgment, my lords. This is 1961. What must be? SSC Online, page 9, my lords.
Yes.
Well, its relevant paragraph will be paragraph 20. They were dealing with, well, it's a certain provision under the UP Act. If my lords have para 20 minutes?
Yes, please.
On the authority of Baburam Upadhyay's case, we must hold that if the provision in para 241 of that a police officer on acquittal by a criminal court may not be punished departmentally when the offence for which he was tried constitutes the sole ground of punishment is mandatory and not directory, the order of dismissal is wholly invalid. It is quite clear that the words may not be punished in the collocation of words used is equivalent to shall not be punished.
Is the Constitution Bench judgment?
Yes, my lords.
Yes.
Have you made copies of the All England Law Reports?
They have that.
Well, interestingly, my lords, this very preposition actually came up for consideration way back in 1874 before the House of Lords. And the Earl Crane, my lords, as he then was the presiding officer of the House of Lords, my lords, I'm placing this judgment before your lordships, my lords. This is, my lords, All England Law Reports, 1874, my lords, 43. If my lords have it.
Yes.
I'll read right the beginning minutes. The words, "It shall be lawful in a statute," are plainly and unambiguously merely permissive, empowering and conferring on the person named a right to do a specified thing. But when the object of the enactment is to effectuate a legal right, whether public or private, they are to be construed as compulsory. This is equally the case when the enabling power is given by the word "may." So therefore, my lords, the second part of that would have to be read as "may not."
Yes.
No, this is the other one, right? This. Give me the relevant paragraph.
Paragraph 8. We have given this.
It's given in the list of books. Just take a paragraph. Well, there's one more authority on something very close. Well, it is AIR 1963 Supreme Court, page 1618. This is again a 3-judge bench.
1963.
Ballots.
Page
1618 millets. The relevant paragraph should be paragraph 8 millets. This rule 4.2 deals with the if my lords have it.
Yes.
Rule 4.2 deals with a class of gazetted government servants and gives them the right to make a request to the governor that their cases should be referred to the tribunal in respect of matters specified in so and so. The question for our decision is whether the word "may" in Rule 4, which confers the discretion to the governor, the word "may" in subrule 2 confers the discretion on him, or does the word "may" in subrule really mean "shall" or "must"? There is no doubt that the word "may" generally does not mean "must" or "shall," but it is well settled that the word "may" is capable of meaning "must" and "shall" in the light of the context. It is also clear that where the discretion is conferred upon a public authority coupled with the obligation, the word "may," which denotes discretion, should be construed to mean a command. Sometimes the legislature uses the word "may" out of deference to the high status of the authority on whom the power and the obligation are intended to be conferred and imposed. So, Millets, when the law says, Millets, you may have anybody, but he may not be a legal practitioner, Millets, that would essentially mean that he shall not be a legal practitioner.
Okay. Yes. Reply anything. Yeah, I think, I don't know, tentatively, I think it's clear that, may will.
Yes, sir.
It is mandatory. It's not directory.
Provision is clear, Milord. And one thing which my learned friend has not stated is the judgment of division bench of this honorable court, Milord. We said that the information commissioner has no right to stop the lawyer from representing, Milord. That division bench is also binding, Milord. Can we see that division bench? Only one paragraph of that.
That, Millets, may not have a bearing because the division bench does not strike down the provision. If they struck down the provision, it is innate.
To the petition.
That's the problem.
No, they've not annexed it. My apologies.
Judgment of your lord.
I keep 50 things inside the file. Can't find anything when I need it. Remove all this. Para 22 millets.
Just Umanath Singh's judgment.
Millets. Well, it's
good law.
All due respect.
Para 22.
With all due respect.
Yeah.
From a careful consideration of the rival submissions, it appears that the appellant has consistently maintained that the State Information Commission can examine the legality of the rules framed by the High Court, and the High Court has no right to be represented by counsel before the Commission. This stand does not appear to be correct in view of Section 30 of the Advocates Act, wherein an advocate, upon being enrolled, has the right to appear before any tribunal or person having the power to take evidence throughout the territory of India. Secondly, if there is any issue relating to the question of legality and validity of any act or rule, it can be tested by the High Court. There is no dispute with regard to the second preposition, my lords. Section 30, my lords, I came before your lordships and made the first submission, my lords. Right of legal representation is not an absolute right. Now, the division bench, my lords, stopped short of setting aside or, my lords, quashing the particular provision. They have not struck down the provision. So, as long as the provision remains, my lords, your lordships are aware, my lords, if there is a judgment of a court and if there is a legislation, my lords, the legislation will prevail over the judgment, unless the judgment, my lords, sets aside that particular provision. So, it cannot come from the Advocate General, my lords, there is a division bench judgment.
Now, hopefully my friend has concluded the argument. Again, I will say again, my friend will jump. Now, the issue, my lord, what my friend is saying, simple proposition is that if your lordship has interpreted the law, the interpretation of law interpreted by your lordship will not prevail. Only when your lordship strike down the law, then the judgment will prevail, my lord. I have not heard this kind of proposition, my lord. Law is very clear. Your lordship has interpreted this provision, and there is no need or occasion to strike it down, my lord. As your lordship has said, the provision is amply clear. Now, I will just show the provision and the two paragraphs of the judgment, my lord. Kindly see the provision itself, because everything falls from the provision, my lord. How my friend is trying to twist the provision itself by saying that it should be struck down. There is no need to strike it down, my lord. Kindly see the provision, page 17, my lord, of the 17. And it says clearly, my lord, personal presence of appellant or complainant, paragraph 6, section 7, clause 7. Appellant, complainant, as the case may be, shall in every case be informed of the date of hearing at least 10 days before the date. The appellant, complainant, as the case may be, at the discretion at the time of hearing of the appeal or complaint by the state, be present in the person or through duly authorized representative, or may not be present. Three situations, my lord. One, be present in person or through his duly authorized representative. Who is duly authorized representative, my lord? Is the advocate here, who is duly authorized, or be and may not be present. All three situations, my lord. Where the State Information Commission is satisfied the circumstances exist due to which appellant complainant, as the case may be, he is being prevented from attending the hearing of the State Information Commission. The State Information Commission may afford the appellant, as the case may be, another opportunity of being heard before a final decision taken or taken any other appropriate state and note to it. Now, 4, my lord. So kindly have 2 and 4 together, my lord. Appellant and complainant, as the case may be, seek assistance of any person in the process of appeal while presenting his point, and person representing him may not be a legal practitioner. So the provision is very clear, my lord, that there is no mandatory requirement to engage a lawyer to get yourself represented. But to say that, look, you cannot be represented by lawyer is twisting the entire reading of this section.
After the decision, see, may not be lawyer, and then when I say maybe, like what do you say that the person representing him, you cut out the knot, then say maybe a legal practitioner. Why should you qualify? See, the only question in the mind of the court now is why it is qualifying word not.
I just explained what has.
It is not superfluous. You see, Mr. Advocate General is not superfluous. This is not. I mean, yes.
No, it's not superfluous, my lord. I'm not saying it is superfluous. What I'm saying is, my lord, that RTI is the authority in RTI. There is no mandatory requirement for lawyer to represent the RTI applicant. So that is why it says may not be required to be represented by lawyer. But to deduce the meaning or to infer the meaning that lawyer cannot appear is twisting the entire section, because it is giving the discretion to the applicant or the appellant either to engage or not to engage lawyer, or to get it represented by a non-lawyer. So may not is in that context, and because, my lord, if 4 is read in that way, 2 will become appellant at his discretion at the time of appeal be present in person or through his duly authorized representative, my lord.
May not
So
be
duly
allowed.
authorized representative. And kindly see, with this very provision was read and interpreted in your lordship by division bench, my lord. Kindly see this. Why? Where is the need to may not is a discretion to the appellant?
Well, come back to para 22 then. You come
Yes,
back
my
to
lord,
this
kindly
judgment,
see
yes.
page 2, sorry, paragraph 2. My lord.
Paragraph?
Sorry, paragraph
22.
I lordship will have the paragraph. No, my lord, kindly have para 2. Para 2, my lord. Para 2 of the judgment. Para 2 of the judgment of your lordship, division bench. Para 2. The respondent filed a writ petition bearing number so and so, seeking quashment of impugnment of 18th March passed by respondent of CIC, with prayer to hold that legal practitioner can appear and represent the parties before the respondent number 3, and also seek quashment of declaration made to persons of rules so relating to personal presence of the appellant or complainant as validity of constitutional and statutory rules. Precisely this issue was there. Now, after brief facts, the brief facts, the lordship will find paragraph 6.
Yes.
6. The appellant again agreed by the order passed by the appellant authority, preferred second appeal through their lawyer, middle of the page, so-called listed the case for hearing on 18th March 2015. Accordingly, respondent number 2 appeared on 18th March before respondent 3 through lawyer, to which respondent number 3 took objection. CIC took objection and made observation by the order dated 18th March that assistance of any person who are legal is not permissible as per provisions of so and so and so and so. So same order which is before your lordship. After the conclusion of 7, after conclusion of proceeding, so my lord, now the provision was analyzed by your lordship, my lord. And paragraph 12, where your lordship has analyzed, division bench of this honorable court has analyzed the provision, my lord. Under section 30 of Advocates Act, an advocate can appear anywhere throughout the Territory of India. Therefore, any tribunal or person legally authorized to take evidence in state CIC has all the trapping of tribunal. Therefore, advocate cannot be stopped from appearance on behalf of the parties, my lord. Division bench is saying, my friend is saying that unless the provision is struck down, this order has got no meaning. On the question of presentation by counsel, Learned Singh has also considered the following judgment of Honorable Supreme Court passed in so and so, my lord. Though the appellant now submits that counsel for the respondent representative should have been allowed by state CIC to appear, but the fact remains in an affidavit in opposition such stand is conspicuous by absence. Learned Singh has referred to the discussion provision under section 2 of the Advocates Act, provide for designation of senior counsel, and also notice that appellant was not an affected party required so and so. Rule further provide for non-disclosure. We have heard, and then conclusion your lordship has seen in paragraph 22. So your lordship, division bench of this honorable court examined it, held it that the lawyer cannot be stopped by CIC. Now my friend is saying that this judgment is not binding on CIC when CIC was party to it, by saying that, look, the provision has not been struck down. Where is the occasion for this honorable court to strike down?
Got to put this up for division bench again because of this judgment.
Well, I'm only saying this. I'm only saying this, subject to what my friend says. I don't want my friend to say that I've interjected again. I'm only saying this, Milad.
Kindly see,
Let him finish, Milad. I'll just point out on paragraph.
Let him finish.
7.2 means what? 7.2 means 7.2 clearly says any authorized representative person can represent, Milord.
Yeah.
7.2, how do I read 7.2, Milord? 7.2 says that right cannot be taken away, and 4 is only giving, Milord, 4 is language simple, giving discretion to the appellant to engage a lawyer or not to engage lawyer. It is not giving discretion to the authority.
See, it cannot be see, Mr. Archival General, it cannot be a provision also that mandates that you only have to engage a legal practitioner. Right, which is the other way. So the thing is that you cannot say that. So if you read in a negative context, see, you read in negative context, that means that this provision has been put in here to allow people to engage people who are not legal practitioners.
Yes, my lord.
Who may not be legal practitioners. That means that the purport of the act would be that only legal practitioners should appear. That also, it's not really palatable.
There is a judgment of Delhi High Court on this similar provision without.
In fact, tentative view of this court is that, it's in agreement with the submissions of the respondent. Why should they put that not after me?
And well, the language is similar to that of the CIC as well. The central law is parameterial.
Give me 2 minutes, Lord. Let me persuade your lordship to your lordship is in agreement with the view of the respondent that the lawyers is not authorized to represent the appellant in the application, my lord, then you will have to allow any person in the process of appeal.
Yes.
Any person in the process of appeal. Now, kindly mark this line also, any person. It is not saying that lawyer is eschewed while presenting his point, and the person representing him may not be a legal. So, in all cases, the choice is given to the appellant to engage or not to engage a lawyer. This is because when it comes to the tribunal, my lord, Section 30 of the Advocates Act and other act says that the lawyers have right to appear, because your lordship will have to see that the choice is given to the appellant or to the respondent to either engage lawyer or not to. He may, because if it is said that this is a clarificatory rules, this rule will not override this rule if lordship's construction is that this rule says may not means lawyers shall not appear. May not means lawyers shall, first 2 is gone as per my friend's argument. 2 is authorized representative, lawyer cannot be authorized representative because 7.4 overrides 7.2. That is his argument, my lord. Second, what he says that Section 30 of Advocates Act is also rule will prevail over Section 30 of Advocates Act. Then third argument is that division bench judgment, which clearly says that lawyers cannot be stopped, and inviting your lordship to decide against the order of the division bench, my lord, which is binding on both the parties, my lord, where similar identical issue was raised and then it was decided, my lord. The issue is whether the CIC can violate the order of division bench, my lord. That issue also should your lordship considered. And similar issue was, my lord, in fact, I have placed the judgment also of the Karnataka High Court. Also, my lord, that is 2021 SSC online. That document will be there, my lord. The division bench also has taken identical view, my lord, in the case relating to well maintenance, where also there was a bar clear bar of representation by lawyer, which was struck down, saying that it cannot be struck down. Held. Here there is no bar. In my case, if I can place that judgment, advocate KG.
But the thing is that there's a question of striking down. Here, that situation is not there. It's just an interpretation.
And that has already been done by division bench, my lord.
That is why there's a difficulty with this bench now.
That is, the division bench has already interpreted.
I will deal with that.
But there is no scope of surrender. If he says something, how will I counter, my lord?
No, man, it's on law. It's not what he has argued at the first stage. If had he argued this at the first stage,
I have argued everything. I have due to Mr.
Then there was no occasion for my learned friend to come back again.
I have not argued
If he doesn't want me to respond, Para 22 millets is very specific. Sorry.
Okay. Yes, Mr. See, now he's even on mute. Yes. Hear you. Yes.
Yes. Lord, so the law is per se very clear, my lord. 7.2 is clear, 7.4 is clear, and even may not is not saying that law may not means shall not by the law, shall not by the lawyer. May not by, you have the choice, you have the freedom to engage anyone, including lawyer. Including lawyer. That is how the provision is construed, my lord. I can place similar, may not cannot be construed that shall not will be by lawyer.
Okay, let the court examine it also. I'll listen for further hearing. Very interesting point. But the thing is that only that division bench judgment stands in the way.
Well, it's insofar as the division bench judgment, para 22, your lordships have read it. Why I say, millets, that will not be applicable is primarily because of 2 reasons, millets. Your lordships will see whether any ratio has been laid down in this judgment.
That is why we'll examine it. We'll examine it.
In my humble submission, millets, the ratio is not laid down. Number 2, millets, if my friend can allow me to finish. Which is why in the first place I had said, millets, whether there is a conflict of interest for the Advocate General to appear, millets, this is again another issue that's going to come in. Because admittedly, like it or not like it, millets, there is a law. Now, the law provides something. Now, my lords, the division bench of this court, even dealing with this.
Do one thing. The hearing is inconclusive. This is matter up to 2 weeks. I will examine it. Yes.
My lords.
Let me just do some research.
Well, this issue is very interesting.
Very interesting because
that's why I pointed out that now, what the law commission says is, I was examining it, what the law commission says is that probably the legislature, instead of
examining other tribunals where like family courts, how?
Your lordships, another close occasion to this will be the CCS rules. Under that, in an inquiry, you are permitted to, you can engage a legal rep, you can engage somebody, as a assisting defense assistant, but he may not be a legal practitioner.
Now
there is no such. There is a clear bar. In the CCS rule, there is a clear bar that lawyers and it is an internal department.
That will look at it. Yes. You can't when you available physically next.
It would be better, yes. At least we'll not create a cacophony.
Yes. Then otherwise, you can counter each other more effectively in person
without having the effect of a cacophony.
Yes.
42.
That's exactly why it's very difficult also.
Sometimes we prevail a little overdue on your lordships, yes.
Yeah.
Like.
Yes.
But this requires to close, my lord. This contempt is 2016, my lord. And they have not been able to file anything because there is a repeated direction to them to point out file an affidavit, what are the violations. Over the period of 10 years, my lord, 10 director generals have changed, my lord, 10 union home secretaries have changed.
And yet they choose not to comply with the orders.
Also, these are contempt proceedings, my lord, ultimately. My lord, may I place the other connected matter because for 9-10 years, these two matters were connected. One was disposed of, my lord, similar. And now this remained pending, my lord.
Well, it's because here the difference is there the position was different, Millets. Here they say that they've complied with it. We only say, Millets, that the compliance is not correct because what we were getting earlier, we are not getting it now.
Been done. What order is that?
There are two contempts, my lord. One Madhuvendra Singh and one Prakash Chandra Sharma. They were going together for almost 10 years, my lord. This somehow came to be disposed of, my lord, giving them liberty to go and file a petition.
No, that would be guided by paragraph 11 of your lordship's judgment, Millets.
To last page.
Para 11, so have changed complexion.
Yeah.
Here, Millets, the difference is, Millets, they say the position is, they say that they've complied with it. We are only saying, Millets, the compliance is not correct because what money we were getting earlier, we're not getting that money. That's why your lordships has segregated these matters.
Show that affidavit. You're supposed to.
That
last time was. That's what this court.
My lords, what I
show exactly where the order.
My lords may have it next week. My lords, we've received the pay slips.
31,725. Can you see the order?
31,725.
Because I am also answerable to my department also. 31,725.
Last opportunity, 1 week's time is granted for affidavit. Feeling the content will be closed. Yes.
Well, the people fight the case right up till Supreme Court, and then the department has the audacity to come before lordship saying that we have not.
No, you pinpoint where is the income.
We'll point out. The pay slips, I'm just filing the two pay slips.
10-11 years, my lord.
We bring the two pay slips.
See, why is it kept pending also? Because they've achieved, like they've climbed, like maybe 6 steps or something. And you take contempt, will come back to, to first step again to square one.
That's the intention.
My difficulty.
That's the only thing they're seeking to maintain the anyway.
But my difficulty, I get a reminder, my lord, a warning list that these are the matters pending for 9-10 years and contempt matters.
Yes.
And if only the government of India would have decided to comply, my lord.
43. 43.
This is that matter where it had come before lordships, on affidavit, the lordships. Government had said, this policy is withdrawn. I'm sorry,
they're still the same place as doctors.
Yes. In view of, the submission made before your lordships in the earlier round of litigation, they could not have come with this new policy.
Are you the writ petition? There's a writ petition and there is one contempt application.
Today also is there repetition?
All three matters are there.
All three matters.
We'll hear it today.
Next week sometime.
Okay. Which is the number?
Item 40. Was this?
43 to 45.
43 to 45.
After 1 week is request of the party.
Apply.
46.
Where the election petitioner, my lord, had prepared an affidavit, we have submitted a reply to that. The
What is
allegation, my lord,
Mr.
because this is the case
Yeah?
where we
It's
have
unlike
been
a lot.
served with the
Where's the, you want adjourn today? Hello, you
Let this
adjourn
matter call at the
application.
end of the board, Your
We
Lordship.
adjourn repeatedly, yes.
yes, my lord.
What's it for
Where
today?
the allegation, my lord, we have filed an affidavit, reply to the affidavit. It can be heard, my lord, if there.
Yes.
Let the matter come at the end of the board, Your Lordship.
End of the board, okay. Already end of the board. This court won't be available after 2, so this full court meeting is.
All right.
48.
Loss is matter pertains to that succession certificate.
Yeah?
Succession certificate, loss. Respondent was.
Yes.
Unless my settlement offer will be 80-20 loss out of the gratuity amount. Loss.
The Lordship has said in the last hearing that this is 40%. I have already conveyed. I said, court has suggested for 40%. Can you actually change? So she said it's okay.
It's okay.
The discretion of the court.
Number
Give us 40.
20% loss. 20% loss. Because they have
20%.
20% because they have two children. So 1 lakh.
You've
each
come
loss.
down from last time. Last time you said take 1 lakh. You said take 1 lakh, right?
He himself was agreed last occasion.
9 lakhs, my lords. Out of that, my lords, 2 lakhs will be given to the respondent for the children only. Because under
2 lakh only given.
the 2 lakhs will be given 1 lakh each for the children.
So give 1 more lakh.
1 more lakhs. Will be too much, my lords.
Yes?
1 lakh will be too much.
1 second, 1 second. I've forgotten.
All the children have attained the age of majority. My lords.
One is starting now.
One. Only amount 9,96,000.
Yes.
Yes, sir.
You already gave him 2 lakhs. When?
No, we have not given 2 lakhs. The settlement of our settlement offer is be let them take 2 lakhs out of the 9 lakhs.
Take 2 lakhs then.
It will be too less because I
Because
have
they have
already
2 children,
spent.
my lords.
Yes, sir, because you're not, in fact,
You're not
you don't
entitled
be
to.
order long also.
And all are settled actually. Your Lordship, the petitioner said, appellant side actually, their children are already settled.
Yes.
Everyone is settled. They have
This application
this
under
belongs
section
only
doing the
384.
government job, Your Lordship.
It's an application of section 384 of the Indian Succession Act, read with Rule 3 and 6 of the High Court of Meghalaya, in bracket jurisdiction, which is the Council Courts of 2014. The brief facts are that the appellant had filed an application for grant of succession certificate for the gratuity amount of rupees 9,96,385 lying with the office of the NIPCO. forgery of the I'm not be fact for that. Which of the deceased employee, one late Lal Moana Wargiri. So, the objections were filed by you for a trial court.
Yes.
On objections being filed by the respondent to the application of the appellant, the Bernard court below by order dated. Where's that? Order dated. Order of the Council Court, 2nd October 2024.
22nd October 2020.
That amounts are lying with the NIPCO.
Yes, Marcus.
2024. And come to a finding that as a question of who the legal wife of the deceased between the appellant and the respondent number one not be gone through the proceedings in the proceedings. It was ordered that the succession certificate for the said amount be granted to the petitioner, or to the appellant and the respondent in equal proportions on the principles of justice and good conscience. Next paragraph. In the course of the proceedings before this court, the parties have attempted to come to an amicable solution, amicable settlement with regard to the sharing of the amount in question. Stop. Your Mr. Sorry, next paragraph.
Sir, my name?
Your name.
Arlindo.
Arlindo, the counsel of the appellant, submitted that the appellant is the legally. There's no marriage certificate with you also. You were not legally married also.
We were legally married. We were legally married.
Yes, it will say.
It is later period, Your Honor.
Anyway,
page 19.
Mr. Arlindo submits that the appellant is the legally married wife of the deceased employee, and as per the records of maintained in the office of the NIPCO, as can be seen from the records, has been entered in the service book as the legally married wife. So, no objections have also been obtained from the close heirs with regard to the appellant obtaining the succession certificate. But however, on the objection filed by the respondent, the self-succession application before the so this was on Prohibitions, the court below had passed impugn order. Stop. Now, Ms. Anna Chowdhury, what submission? She submits that the respondent also the legally married wife.
Yes.
You haven't said that before the succession cohabiting.
Your point. Yes.
That submits that notwithstanding the materials in favor of the appellant, the respondent had cohabited with the deceased employee, and as per the findings of the court below, the same is an accepted custom which will constitute a valid marriage. Stop. He further submits that there are two issues.
Two issues.
Two issues. That the first submits that the deceased employee and the respondent have two issues out of this union, though they're major now.
They are
Major
yes.
now.
And though major now, and then and notwithstanding the fact that they're major now, in view of the relation that the respondent had with his employee as husband and wife, is also entitled to an equitable amount of the gratuity. He further submits that it is on this consideration and our findings of the court below that the order was passed, allowing part of payment to be made to the respondent. This court has examined impugn order and also the other materials available before this court. Yes, news courts up. An examination of the same would show that the appellant has certificates from the church, as also from the records of the NIPCO, in support of her claim. However, the respondent also has produced materials. Where's that? Darbar Samotawar materials. Materials.
What was moderated here?
I have no show cause.
So,
Close.
as for materials from a church and for Darbar Samotawar, supporting the claim that she also was the wife of the deceased employee. This court notes that the same is a vexed question, and as the fact that the respondent had cohabited with the deceased employee cannot be. And what? Police में स्वागत है. Also can be ignored, though it is clear that as per the records and the marriage certificate, the appellant was the recorded wife of the deceased employee. In the constitutive report, therefore, the balance of convenience or facts would weigh in favor of the appellant. But however, without lingering with the matter any further, and on submission of the appellant, who submits that the sum of 2 lakhs will be made over to the respondent to bring a quietus to the matter. What's your submission?
3 lakhs at least, maybe.
Yes.
3 lakhs at least.
Too much.
Mr. Chaudhary, though agreeable to bring a quietus to the matter, prays that at least 3 lakhs be given. So, on finally, as there appears to be some consensus with regard to a settlement, but only a variance with regard to the amount, this court deems it fit for the ends of justice that the respondent be allowed 2.5 lakhs. Yes, as a final, as amount final settlement of the matter. So, accordingly, this first appeal, without going to the merits of the matter, examining the grounds or appreciating the evidence, disclose correction that disclose by allowing the respondent 2.5 lakhs from the gratuity amount of rupees so and so. Matter stands closed and disposed of this. Give us something also. Yes.
49.
My lords, wait, please, lordship. Lordship, this is this matter, lordship, which concerns quantum of reservation for scheduled tribe from Meghalaya in State Bank of India, lordship. Lordship, can have this matter after 2 weeks, lordship. Yes, I am awaiting certain instructions, lordship. It's a very important matter.
Have you filed affidavit?
They have filed.
Then if I rejoinder.
Yes, lordship. We filed.
Mr. S. Pandey prays that we allowed 2 weeks time to obtain further instructions in the matter. Only less up to 2 weeks.
My lord. Diplomat.
52.
In this case, I have earlier stated that main accused has filed the appeal before this state tribunal.
What happened?
Now, on 2/7/26, Learned Tribunal has decided the case and set aside the order original in entirety.
Where's the order?
And
this will follow then.
yeah, so এটা ঠিক আছে দেন না and directed to release the gold. So therefore the foundation of this writ petition no longer survives, and I pray that this penalties imposed to the family members, 8 family members, may kindly be set aside.
Yeah, Dr. Mojika, we'll have it after 1 week take instructions.
But my lord, as
You're
far
aware
as
of this?
I'm not disputing about this order, my lord. But as far
That's why you take instructions.
But as a further additional relief from this honorable court.
No, he's not going to ask any further relief. You just examine the order. Up to date, Mr. Endas Gupta submits that the main in the matter wherein the main accused
Dorendra Singh.
Yeah, the main accused, one Shri
Dorendra Singh.
O Dorendra D.R. and D.R. Singh. No? No, not in the main matter. Mr. Algota submits that the main accused, Sri Dorendra Singh, had preferred a statutory appeal before SESTAT CSDAT, and that a final order has since been passed on 2/7/2026 allowing the appeal. He therefore submits that nothing remains for consideration in petition, and that appropriate orders be passed to set aside the penalties imposed upon the
family members
of the said Dorendra Singh. Yes. Copy of the orders also been supplied to the court. Next by Dr. N. Buzika, prays for 1 week's time to obtain instructions in the matter. Just after 1 week. Copy of the order dated 2/7/26 is taken on board and made part of the record. Yes.
53.
Much obliged.
My lord will kindly produce the order dated 12/6/2026.
Yes.
May it please your lordship,
It's clear.
before my friend submits, my lord, there have been certain developments in this matter. The subsistence allowance has been released till June, amounting to about 24 lakhs, my lord. And also, there's an
You
order.
were suspended for how long?
It's more than 6 years now, my lord. And not a single penny paid to me.
Now
Only
you've
paid.
got
Yes.
24 lakhs.
I haven't.
paid.
As of now, I haven't.
Then?
It's been released, lordship.
Has he signed it anyway?
No, no, no.
It goes
has to
directly
be
to the bank.
credited into my bank account, my lord.
It's been released.
It has not been communicated to me.
2nd of July.
I haven't received
Maybe a
it.
client not communicated to you.
Yes.
No, 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 no. We have. We are in constant
When it comes to amounts, they won't communicate to the lawyer.
And there have been certain developments, my lord. The writ is infructuous.
Why?
Because as per the order of 1st of July 2026, my lord, at the last paragraph, my lord, second page, last paragraph.
1st of July of this court.
No, my lord. The order passed by the Deputy Commissioner.
Last line.
The last paragraph, my lord.
Major penalty. Do you have copy of this?
No, my lord.
Today, MS Engineer Shilla,
Then in the
senior advocate, has produced a communication dated 3/7/2026, which shows that the substance allowance due to the petitioner has been released to the tune of. Yes, you've got more than 44 lakhs.
Lordship.
No.
No, lordship.
24.
1/9/2019 to 3/31/10/25,
Lordship.
20 lakhs. Then 1/11/2025, 30/25, 24 lakhs. Then, oh no,
No, no
24,000.
lordship. It's 24 lakhs total, my lord.
20 lakhs and 24,000.
2 lakhs.
And 2 lakhs, 24, 49 years. So, no? Has since been released with the final installment, with the final amount being paid on 2/7/2026. Further, an order dated 1/7/26 has also been submitted for this court, showing that the penalty of dismissal from service has been inflicted upon the petitioner. Top copies of the same are made over to Mr. Argurum to take instructions. This after 1 week.
My lord, okay.
Much obliged, my lord.
Copy of the order may be given
Yes,
to me,
made
my lord.
over.
Both.
Copy.
Yes.
55.
Thank you.
55.
So you can take material instructions.
Much obliged, my lord.
Yes.
Your lordship, I may be permitted to withdraw this petition.
Yes.
No.
The ME Ahmed prays that commit instructions that may be allowed to and prays that the he be allowed to withdraw. Yes. Because the match stands close on withdrawal. Let's pray.
58.
Okay.
Wait, please.
My lord, I'm the proxy. Allow me, please. My lord, I'm the proxy counsel here. I've got information from Mr. B.K. Singh, my lord. He could not make it to Shillong today. There was a certain situation in Khanapara. That's why he had to go back, my lord. There was a flood situation. Something happened to his car. He had to go back. He apologized.
Taking time, lordship, more than I have not taken single empathy. Lordship.
This is my
How
instruction.
did you come? By boat?
By route. Earlier occasion also
The flood's over.
over, lordship. Over. There is no flood, lordship.
No flood.
No flood.
How come Mr. Basing was
I
affected by
do,
flood?
my lord, this is my instructions from him. He just called me, my lord. I'm the proxy
Earlier
counsel.
occasion, lordship, when I appeared, lordship, at 3 p.m. to 2 p.m., he says that today he is unable to attend the court, lordship, in online. Earlier occasion, he is taking time, lordship.
Affidavit has not been filed.
Hi, lordship. My problem is that I admitting amount of 1,490 lakh has been stopped, lordship. I am a small
You can't
contractor.
come online also.
My lord, he says that he's not able to.
Okay, we'll listen supplementary this on. You try a luck on today's 15th.
Yes, my
try a
lord.
luck on 22nd.
22nd.
Yes. As a prayer been made on behalf of Mr. B.K. Singh, Leonard Council 2 and 6, who could not travel to Shillong due to
He says flood situation in Khanapara, my lord. That's what he told me.
flood situation. Stop. The matters adjourned to 22nd. Stop. Yes.
Obliged. Most obliged.
Do one thing, you inform him so you can.
Yes, my lord.
Together. You inform him.
Yes, my lord, I'll do it today. Today itself. Right now, my lord.
Obliged. Same lordship.
It's connected, my lord.
Connected.
61.
KHDC matter.
Yes, we'll have to rise, I think. Are you ready to the matter?
I'm just a formal party, your lordship. The district council is the.
How long will you take, Mr. Chaudhary?
It will take some time.
Because we have a so-called meeting also at 3 or 2:30 years.
The KHDC is.
Because the issue is very simple in a way, my lord. My lord, trade license.
We have to give you a proper hearing.
That has to be.
So if not inconvenience you, I think the time, we have a certain time constraint.
Some urgency in the matter.
Today will be a bit difficult, Mr. Chandraso.
Next week, next week.
Yes, you take a date kindly next week.
My lord, I will go.
Because it's low on the list, so it's a bit difficult.
If not next week, my lord, thereafter, my lord.
On the period of parties list and so on. So that's what.
Second call, item number 46.
Yes. Yes, Mr. Deb. You take a date, Mr. Chaudhary.
This was on the issue of, my lord, presentation and serving of true copies. There is a.
You mean to say that we're still in the 711 application?
My lords, yes. Here, my lord, what has happened is that.
So Mr. Pandey has effectively shut you out till the next elections.
Well, there is nothing in the matter, my lords. The affidavit is misconceived. My lords, a mere perusal of my reply, my lords, will clarify the issue. Their case is that they have served me a proper copy, and that copy was served dusty. Till today, we have not, my lords, seen the affidavit of service. There is no information as to whom that service was made. They say that it was served to the councils, but the wakalatnama was filed by the respondents, my lords, after the dusty service, so it could not have been served on the councils. So, my lords, effectively, I have annexed the copy of the election petition that I have received. It does not carry the signatures. It does not carry the my lords, stamp and anything, my lords. So that is an admitted case that the copy that I have is not in compliance with section 81(3).
No.
The only question is whether the copy was served on me or not. There is no proof that any proper copy was served on me. There is no proof of dusty service. Secondly, and most importantly, in paragraph 6H of the affidavit, they admit that yes, one copy which was served to you was not in accordance with section 81(3). So there is no relaxation available in law that you can serve. Let us assume for a moment of argument that whatever they say is correct also. Can you serve another copy which is not in accordance with law? That is not provided in the Representation of People's Act. So, this case has no legs to stand.
If I may take your lordships, my lord, to the reply.
It's very short. Completed today. You take a date. You're due to.
We can argue it out in detail.
Due to paucity of time, this matter heard. So the matter has been taken up for hearing due to paucity of time. The matter will be fixed on.
Subject to his any date.
Take a date, yes. Shall be refixed on? Yes.
After 2 weeks.
After 2 weeks, yes. Just on so and so.
Obliged.
Obliged.